চিফের কোনো কিছু এসছে? জানো চিফের কোনো কিছু এসছে? হ্যাঁ,
অনলাইন আছে না বলেছি।
সে ঠিক আছে, চিফের কিছু এসছে? সেনগুপ্ত সাহেব অ্যাসাইনমেন্ট এসছে? যাক। Oh,
So that is why.
call the list. My lord, may I have the liberty to mention, my lord, this is pursuant to a my lord, just give me a minute.
Yes.
My lord, there was an urgent matter which was heard by Justice Sengupta. My lord, that matter, my lord, since Justice Sengupta was not sitting,
Justice?
Sengupta was not sitting, my lord. My lord, it was heard by Justice Shubhra Ghosh. But Justice Shubhra Ghosh indicated that since the matter was extensively heard by Justice Sengupta, Justice Shubhra Ghosh was loath to take it up and said liberty to mention the matter was scheduled to come up on Wednesday. On Wednesday before Justice Sengupta. But nobody anticipated that Justice Sengupta will not be sitting possibly for the week. So, my lord, we went back to Justice Shubhra Ghosh. Justice Shubhra Ghosh indicated that since I've already ordered, I'm right now not in a position to take up the matter. My lord, the matter was mentioned before the Chief Justice. The Honorable Chief Justice indicated that we should give everything in writing to the Honorable Chief Justice. So we gave everything to the OSD and as directed by the Honorable Chief Justice, and it was indicated in the second half of the day at 3:30, my lord, by the Honorable Chief Justice, that the OSD shall inform as to where we shall go. But the OSD is informed that we should mention this matter, the concerned matter, before your lordships.
But what is the urgency that only for this day this determination is assigned?
My lord, the entire week, my lord, he has not said, my lord, we have an urgency, my lord. I'll tell your lordship, my lord, while the matter was being heard, Justice Sengupta, my lord, the issue of
this only for this day.
Yes, my issue is, my lord, your lordship would hear me.
You are waiting for last,
my lord, in the meantime, my lord, on 2 occasions.
Today, only for this day, this determination
But
is
for
assigned.
6 days we've been roaming around. From
only for this day, this determination is assigned, Mr. Banerjee. Wait for a day, since you are waiting for 1 week.
Not 1 week, my lord. It was heard on last Thursday.
Yes.
And Monday it was supposed to be heard peremptorily at the direction of Justice Sengupta. Saturday and Sunday, my lord, they conducted raids in my house to arrest me.
No, not true.
Where do I go?
Wait for a day.
My lord, yes, I want to mention one anticipated old parents, my lord. Old parents, my lord, son is in custody, my lord.
Why you are mentioning?
Anticipatory bail, my lord. Anticipatory bail.
Anticipatory bail. I have determination only for this day.
Yes, my lord. My lord, old parents, my lord, apprehending, arrest any moment, my lord. Son is the custody, my lord. State.
No, sorry. My lord, for a day, only for this day, this determination. I am not going to take up.
Mention, madam, only for non-prosecution, madam. In anticipatory.
Mention on one day, 2 days, not the mentioning day.
Only for anticipatory bail application, madam.
Anticipatory bail application, non-prosecution, mentioned before the bench when the regular bench will be available. Yes. Please call the list.
Item number 1.
Madam, for the petitioner led by Mr. Shubhendu Bandyopadhyay. Affidavit of service to the court. This is the affidavit of service, my lord. Yes, yes, my lord. The matter related to a petitioner and his wife is a senior citizen, and they are most the unfortunate parents, my lord. They have a son, and the petitioner have some chronic heart problem, my lord, and the son, the son and the elder son's wife, my lord, gave him a threat to remove the property from his house to shift the property. Yes.
What about the service upon the private respondent?
Yes, my lord, we have served.
Well, we have already served page 8 and 10, madam. In earlier occasion, madam, your lordship took the matter on 23rd June. In earlier occasion, your lordship taken the matter on 23rd June, and that time we have already given
that you have served because affidavit service is not on record.
Yes, my
yes,
lord, we have served. This is the affidavit of.
Yes, find it out when the private respondents was served. It was filed on 10 June.
Page 8 and 10. It has been served on 17 June. May I hand over? No problem.
Yes, what is the matter about? You are appealing for the state.
State Lordship.
What is the matter about?
But my lord, the petitioner is a senior citizen and he is suffering for his heart. He is a heart patient. Since the marriage of his elder son 2017, his son and daughter-in-law has been seriously tortured, mentally and physically tortured to the petitioner and his wife, only to grab the property and remove from the house property from said premises under the Khondogos police station. But your lordship, we have several times representation before the officer in charge of the Khondogos police station and the superintendent of police of the Burdwan district, and also Divan Justice. They did not take any steps, my lord. If your lordship kindly trouble to turn in my medical report, well, page 22. Page 22.
Oh, what police authority will do regarding your medical?
I already saw 27. My page 27. In my representation, we have already communicated 27, 27, 28. May you permit to read, my lord?
ভিলেজ রিপোর্টটা আছে গড়িয়াহাট থানার।
Now, whether any FIR has been registered?
FIR has been registered, Lordship. What had happened is, I will be candid with your Lordship, the petition of complaint in the first instance got lost. Then the police contacted the petitioner, took another copy of the complaint, and the FIR has been registered. Page 3 of my report will indicate the same, Lordship. Straight.
Against whom you have lodged complaint?
In my to my
Elder son.
elder respondent number 9 and 10. Elder son and daughter-in-law.
How they are related to you?
Elder son.
Elder son and daughter-in-law.
Daughter-in-law. Man, we have already filed demand. We have already sent demand justice. My lord, page 38, my lord.
Now the complaint has been transformed into an FIR. Now the case has started. Now what today what you
I
are
want-
praying for?
My lord, I'm already too concerned with a peaceful position in my premises.
Peaceful position.
Peaceful. I am residing in that premises under the Khondogos police station. Therefore, I am praying before your lordship to restrain the private respondent not to disturb in any manner whatsoever, my lord. For my peaceful position. I am also senior citizen, my lord. In nothing upon this, I am placing before your lordship and on remain judgment, my lord. Your lordship.
Now you are staying where at present?
In my premises.
So then you are staying there. What is the
Staying
problem?
Direct the police authority to maintain peace and tranquility and over the property and not to disturb the private restaurant in any manner. That's my prayer.
And what is the complaint against your son and daughter-in-law?
I have already complained, my lord.
Yes. What is the contents of the complaint?
They are using the filthy language and mentally and physically torture, my lord. I have written there. My lord. And then also I send my demand justice, my lord. In page 38, my lord.
But you have referred to one charge sheet already, Mr. Das. Charge sheet number 2233 dated 31st January 2023.
That is in the complaint which the daughter-in-law has filed against the petitioner under 498A.
And what is the case registered against the petitioner by the daughter-in-law? Where is the particulars of that?
Lordship, page 2 of my report, last paragraph on 4/7/2025, again Subarno Shaha, daughter-in-law of the petitioner, lodged specific case Vide Khondogos PS case number such and such against the present petitioner, his wife and younger son. After completion of the case has been ended in charge sheet.
Where is the second paragraph?
Last paragraph, Lordship. Beginning with on 4/7/2025.
No, with regard to the charge sheet, I am asking you, because that is the charge sheet dated 31st of October, January 2023.
First daughter-in-law lodged a complaint against under 498 penultimate paragraph of page 2. Later, daughter-in-law, namely Subarno Shah, lodged specific case against the present petition under 498A such and such, against the present petitioner, his wife, his daughter.
Second page,
Second page,
last paragraph,
penultimate paragraph and last paragraph.
ultimate paragraph. So in connection with Hondo Court PS case number 1023, this charge sheet dated 31st of January
Is
2023.
filed. Thereafter, another complaint was received, which is reflected in the last paragraph of page 2. That in that case also charge sheet has been filed.
If your lordship kindly
Just a minute. And based on the complaint of the petitioner, this 191/26
191/26.
issue. Affidavit of service filed on behalf of the petitioner is taken on record. In spite of service of notice, respondent numbers 8 and 9 are not represented. Next paragraph, learned advocate for the petitioner submits. Learned advocate for the petitioner alleges torture and threat at the instance of his son and daughter-in-law, being respondent numbers 8 and 9. And to that extent, a complaint was lodged with the concerned police station. Stop. Petitioner prays for steps to be taken by the concerned police authorities, which would prevent respondent numbers 8 and 9 from threatening the petitioner. Next paragraph, Mr. Das, learned additional government pleader, represents state respondents, has filed a communication dated 22nd June 2026, and same is taken on record. Stop. It is this stop. Copy of the said communication is made over to the learned advocate representing the petitioner. Next paragraph. It is disclosed in the communication dated 22nd June 2026 that there are complaints and counter complaints giving rise to criminal prosecutions. Stop. Daughter-in-law, respondent number 9, being the daughter-in-law of the petitioner, lodged first complaint, which gave rise to a criminal prosecution, being Khondokos Police Station case number 10/2023 dated 10 January 2023. And same was culminated into filing of charge sheet, being number 22/23 dated 31st January 2023 before the jurisdiction magistrate. Stop. There was another complaint by the respondent number 9 against the petitioner, which gave rise to another criminal prosecution, being Khondokos Police Station case number 192/25 dated 5th July 2026 under certain provisions of BNS. And in connection therewith, charge sheet being number 211/25 dated 30th July 2025 was submitted. Next paragraph. However, having received the complaint of the petitioner, a criminal prosecution, being Khondokos Police Station case number 191/26 dated 22nd June 2026 has been initiated against respondent numbers 9 and 8, respondent numbers 8 and 9 by registering FIR. Concerned investigating agency is directed to take is directed to expedite investigation and take the criminal prosecution to its logical conclusion by filing report before the jurisdictional magistrate. Next paragraph. However, concerned police authorities are directed to maintain peace and tranquility at the local peace and tranquility local peace and tranquility, and to see that no untoward incident takes place. And writ petition stands disposed of. Arjun Xerox Center. Okay. Great.
Directly,
Disposed of.
authority not to disturb in any manner, madam.
Next matter.
Tranquility বলে দিল।
No, any manner.
Item number 2.
আমাদের বেশি পাওয়া যায়।
Before your lordship, my lord, the unfortunate father whose daughter is missing from April 2026, my lord. During search, they came to know the film. It's probably 5 to 8, my lord. They kidnapped the daughter of the petitioner, my lord. We have lost the complaint. Case has been started, but the daughter, my daughter, till now not recovered, my lord. I humble prayer before your lordship, my lord, kindly direct them, my lord, to recover.
When daughter went missing?
April, 2nd April of 2026, my lord. 3 months already over, my lord. Second, no? Mr. Age of the victim, sir. Minor daughter, মানে কত 14-15? আচ্ছা, তো এরপর দিন ধরে গল্প হবে না? পুরো অ্যাটেম্প মেজরিটি হবে তারপরে আসবে। বিয়ে করে নিয়েছি, বিয়ে ছেলে মেয়ে। তিনের রিপোর্ট চলে যাবে। জানা number মানে বাইরে সামনে থাকলে আমাদেরকে সেটাকে অবজার্ভ করতে হতো।
Steps are being taken by the school of police authorities. Arrests are made. Then several raids were conducted. CID was directed to circulate the picture of the victim girl, but till date it not
Recovery of my daughter, my lord, that is my
Lordship,
kindly keep it is my anxiety, my lord. Kindly keep it pending.
also I am contemplating.
I will keep coming up with the progress report because Lord will see, kindly take from page 2 of my report, the third last paragraph after annexure F. I don't want to say the details of it, what is mentioned. So once this is completed, a further status report could be given.
Issue.
We have got a report of the.
We will supply a report.
My lord,
Yes, not at this stage.
not at this stage.
No.
Something sensitive কিছু জিনিস।
That will not serve any purpose. Affidavit of service filed on behalf of the petitioner is not is taken on record. Stop. It is submitted by the learned advocate representing the petitioner that father has, is the petitioner.
Yes.
That petitioner's daughter went missing on 1st April 2026. But till date, she has not been traced out. Stop. On lodging missing complaint, the missing complaint was lodged. However, dissatisfaction is expressed on behalf of the petitioner with regard to the two steps taken by the concerned police authorities to find out victim girl. Next paragraph. Mr. Das, Learned Additional Government Peter, representing the state respondents, has filed a communication dated 29 June 2026 of officer in charge, Belda Police Station, Paschim Medinipur, along with certain documents, and same are taken on record. Stop. It is disclosed in the communication dated 29 June 2026 that notice was issued under section 180 BNSS. Thereby, available witnesses were examined and statements were recorded. Certain raids were conducted and arrests were made. But stop. Efforts are on to find out the victim girl. Stop. Concerned police authorities are directed to continue endeavor to find out victim girl at an early date. Stop. Let further report be filed disclosing the steps taken in this regard. Next paragraph. Hearing of this matter stands adjourned. This the matter under the same heading for further consideration on 30th July 2026. Next.
But I appear for the petitioner.
Yes.
But this is a matter relating to Pathovan school. But the school is being run by an ad hoc
So
committee.
if the school is the petitioner, why it is before me, before this court?
It's a police in action matter.
There is absolutely no police in action involved.
have the instruction to appear.
But may I make my
But if
submission?
it is part of our school,
May
I
I-
cannot take up this matter. I have to release
There
it.
have
on
been
process.
defalcation of funds, etc. FIR has been registered, investigation is going on. There is actually interstate dispute between rival factions in the school.
Matter
Person
is
to inaction
released on personal ground and we placed before the honorable the acting chief justice and is placed before the honorable acting chief justice for assignment. Take it back, Mr. Das.
Track রাখতে হবে। চারের report. Item number 4.
My lord, Anishur Rahman is appearing on behalf of the petition. My lord, I'm paying for not today, my lord.
Why?
My lord, he's ill. He's
Who is he?
my lord, my senior, Anishur
Who
Rahman.
is your senior?
Anishur Rahman.
What has happened to him?
My lord,
Where is the service of notice? At the time of call, accommodation is paid for on behalf of the petitioner. Since learned advocate is unwell, however, state respondents are represented by learned advocate. Stop hearing of this matter stands adjourned. List the matter under the heading July 2026. Stop. Learned advocate for the petitioner is directed to complete service of notice. Whether private respondents are there? No. ছেড়ে দাও, কিছু বলতে হবে। Yes.
আমারই নাম লিখেছি। My lord, say my lord, item number, my lord. Twenty.
Same prayer,
Yes, my lord.
same prayer, same repetition. How
No, my
is it
lord.
possible? Well, same order, 28 July.
We are for the petitioner being led by, I'm led by Dr. Singh Vimalas.
Yes, for place your case.
Yes, madam. It's regarding, we have filed this application regarding the freezing of the bank
It's a
account.
badge you are appearing.
Yes, but aren't we briefed? Let Mr. Nandi do it. There are some matters where we can take it easy. Dr. Singh is appearing.
But it will kindly peruse. First, may I just place, Malad, the communication. It's at page 40. Page initial only.
Page 40.
Page 84, Malad.
Your three accounts are debit freezed.
Yes.
Yes.
Now, Malad, on the basis of a complaint. Now, Malad will kindly peruse the complaint once.
Yes. Page
Malad, it's page. Page 41.
41. Yes.
Malad, to the inspector, Cybercrime Police Station, Bidhannagar.
Yes.
Malad, this mostly respectfully submit that this written information bring to your kind notice certain serious and credible inputs which discloses a reasonable suspicion regarding commission of cognizable offences involving the generation, routing and possible concealment of
Generation, routing and possible concealment of funds
funds
electronic
through
and banking
electronic and banking channel. It comes
Don't take so much time to read
No,
this letter.
no, ma'am.
Be quick.
Yes, ma'am.
Yes.
It has come to my knowledge through reliable circumstances. It's a knowledge. Through reliable circumstances.
Yes,
surrounding
the
development,
accounts are referred to.
that's
That the pattern of such suspected financial movements give rise to a reasonable apprehension that electronic communication system, digital platforms, and online banking mechanisms may have been used to facilitate.
May.
May have been used.
I'll read it
May have
slowly,
been
ma'am.
used to facilitate the transfer of then
Mr. Dotto is here.
Then yes, you carry on, then Mr. Doctor will join.
May have
This
been,
letter, complaint is,
rooted and subsequently
and
deposited.
then the next paragraph, the relevant part is that there is also a reasonable apprehension
Yes,
that if prompt action is not
not taken.
taken, relevant electronic records, banking data and financial evidence may be altered, concealed,
concealed, and
dissipated.
next paragraph. On prima facie assessment,
If we come to the penultimate paragraph, it says that it is further requested that
previous to that is very also
steps
important.
be
my lord.
taken for preservation and securing of all relevant banking records, KYC
Previous
details,
paragraph,
account statement and electronic transaction data relating to aforesaid accounts and the appropriate legal measures to be taken.
my lord, will kindly look into the
Yes.
said paragraph also. On prima facie assessment. Now, what is the assessment? It's not declared.
Yes,
Of
Mr.
the
Rathore.
available-
Yes.
Now, my lord, can suspect all actions. Everything. But that suspicion must be a practical one. Suspicion in the of money work. And fire may be lodged. And expect to action. Normally, your lordships have held section 154 CRPC that if a fire discloses a cognizable offense, the police has no alternative to set the criminal law into motion. Dispute that. Here is a case where your lordship will find that, my lord, the police has, my lord, entertained an FIR, where I'm not going into, my lord, the veracity of the allegations, etc. Let us assume for argument's sake whatever is said is correct. Consider, my lord, whether, my lord, the basis of suspicion, assumption, to motion number one.
Unless any incriminating materials are found.
Right. At least referred to. And what is very important is now we have started with 3 accounts. I am told, my lord, by this time another 5 accounts have also been freezed. I'll come to the powers of the police as well. My lord, it's on the basis stated. But these are the special second suspicion is or this suspected unlawful collection of money. Not to at least one transaction. Fourth, possible concealment of the proceeds. And what is important is that in the 3rd paragraph in the first page, he says that the exact transactional chain are second page. Assessment of the available record, such and such may be extracted.
May attract provisions.
But I have to confirm that what Miller, the complainant's language has to be taken by the police. Let us show for argument's sake that, Miller, on the basis of this FIR, can be taken to motion. What are the charges? Please look into the charges. The charges are under section 111(4). Then 6 ornaments crime.
Are other charges too.
Yes,
There are other sections,
yes. Now, look at the other section.
section 318.
So, 66D of, yes, that
Information technology and organized crime.
yes, yes, I'll come to that, I'll come to that. Police does not know now,
Yes, will satisfy.
which are passed. And Supreme Court has done it's not working in this year. This course, I am charging it. CBT, breach of trust and cheating. All these judgments are there.
Mr. Datt, to be precise, because today court is considering whether any interim protection can be granted or not.
Yes, yes. What Miller, for submission Miller, apart from what Miller, my learned senior would be submitting. Now, crime Miller can be attractive because crime has to be charge sheets in respect of two cases. Then organized crime can be charged with. This is not available. CBT and cheating cannot go together. Dr. Miller goes to 66 CMD. Now, please have a look at section 11. Can you not satisfy the conscience of the court as to whether 111 Miller can be inflicted? I'll come to the power of the court. Please make accounts or not. আছে বলছেন?
Yes.
দে তো একটু।
Organized crime, yes.
Organized crime. Now, please, what is organized crime? The definition is subsection 1. This is vehicle theft, extortion, life-living, economic offense, cyber crimes, trafficking of persons, drugs, weapons, or illegal goods or services, human trafficking for prostitution, ransom, persons acting in concert, selling jointly, that as a member of an organized crime syndicate, of such syndicate, by use of violence, threat of violence, intimidation, coercion, or by any other unlawful means to obtain direct or indirect material benefit, including a financial benefit, shall constitute organized crime. Therefore, so far the subsection 1 is concerned, it is wide enough to include anything and everything. The exceptions to it, or the essential ingredients to it, your lecture will find out from explanation. Explanation for the purposes of this subsection, that I will with the organized crime syndicate, we must keep that mistake RI. Because the section starts with our continuing unlawful activity. Continuing unlawful activity means an act prohibited by law, which is a cognizable offense, punishable with imprisonment of 3 years or more, undertaken by any person, either singly or jointly, as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheets have been filed before a competent court within the preceding period of 10 years, and that the court has taken cognizance of such offense and includes economic offense. The ingredients will not with respect of explanation.
Now, at this stage, when the complaint is lodged and investigation is at the national stage, whether it would be appropriate so far Article 226 court is concerned to enter into the veracity of allegations. Let the investigating agency be permitted to look into this and take steps accordingly. But when the things are hazy and complaints or the issue which is which are available before this court is hazy, now it will not be appropriate so far this court is concerned to look into the veracity of the charges. Therefore, in-depth analysis of the contents of charges or allegations need not be delved into at this stage.
Mayor, at this stage, Mayor, I cannot, Mayor, invite the court to go into two things. One is validity of the allegation, I cannot invite the court. Second is, I am aware that an FIR is not,
Mr. Dotto, here no apprehension is expressed with regard to arrest. Issue which is involved in this writ petition that there are three bank accounts which are lying in a particular private bank, whether it is appropriate to debit freeze those bank accounts during continuity of investigation.
right. Therefore, please, Mayor, take an example, Mayor.
Now the effort of this court today is to look into that to what extent debit freezing of these three bank accounts is necessary.
Right.
Not beyond that, at this stage,
Whether
motion stage.
But the first question with respect is whether has to control transactions into a bank account.
So don't make big submissions on entire issues that can be gone into on exchange of credibility if necessary. But what is the necessity today court is contemplating that this is the germane, the issue which is germane is what is the necessity to debit freeze three bank accounts in order to facilitate investigation.
Right.
Not beyond that.
Wait. For the time period, I address your lordship on that. Now, please have a look at section 106 of the cases. Apropos the lordship's Miller observations.
(106) is related to seizure of goods,
including bank account.
Yes.
Let us see.
Yes, 106.
Yes. Now, 106 is any police officer may seize any property which may be alleged suspected to have been stolen, which may be found under circumstances which create suspicion of the commission of an offense. To seize.
Police officer may seize any property which may be alleged or suspected to have been stolen.
Yes.
Which may be found under circumstances which create suspicion.
Yes.
Any property.
Any property. So the question is, Miller, debit freezing whether it amounts to seizure or not. The respectful submission is debit freezing. The court said that it does not amount to seizure. Does not have control the bank account, which has been upheld by the Supreme Court. Please have a look to this Karnataka High Court judgment. Okay.
Who is appearing for the bank authority?
Minor
এই একটা সাদা পাতালো on debit freezing of account.
on debit freeze.
নামটা কি আছে
কবে দিন?
কপি আমার কাছেও আছে
There are 2 days, 106 months, 102. This is not 102. May the option may kindly take me now, paragraph number 2C. The facts briefly stated leading to this petition are: the petitioners filed a petition under 457 of
Paragraph 2, just a minute, paragraph 2.
yes, but 2C. To come back at a short, please take C. The question is whether the withdrawal of the order, which is in the nature of a prohibitory order issued by the investigating agency to the bankers of the claimant, concerning its banking operations in the accounts maintained by it on such terms and conditions. This is our case. Your Lordship may kindly, instead of troubling your Lordship with the facts, please take paragraph number 2.
It is in connection with section 102,
Now 106.
106, yes.
Paragraph, the counsel for the petitioners contended that under section 102 of the code, a police officer cannot direct a banker to allow an accused to operate the account maintained by him in the bank. A legal direction issued by the police officer prohibiting the operation of an account is therefore one issued without jurisdiction, as the same is not permissible under section 102 of the code. This being the position, the learned sessions judge ought to have ordered the withdrawal of the prohibitory order in support of his submission. The following decisions are cited. The learned state public prosecutor submitted that under section 102, such a direction can be given by a police officer prohibiting the operation of a bank account, but he was not in a position to distinguish the aforesaid mentioned decision cited on the point, or to show how any police officer exercising power to seize any property coming within the ambit of section 102 of the code could issue a direction to the bank prohibiting operation of the accounts. He added that the investigation in regard to the bank accounts of the petitioners, in regard to which prohibitory orders were issued, is over. The investigating agency has obtained the necessary documents in that regard. The court may pass appropriate orders. Then may I, paragraph 12, 102 is quoted. Kindly take paragraph 13. This is very important. Seize is not defined in the code. The ordinary dictionary and natural meaning of the word seize is to lay hold of suddenly or forcibly, to take hold of, to reach and grasp, to clutch, to take possession of by the legal authority. Looking to the use of the word seize and seizure under section 102 and other provisions of the code in the context and the purpose sought to be achieved under those provisions, it appears the word seize denotes taking of possession of any property falling within the scope of the section. Section 102 confers power on police officer to seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of the commission of any offense. Hence, there cannot be any debate.
Explanation is offered in the context of physical seizure, physical possession of a goods.
Right.
But when the issue is concerning bank account, the seizure as contemplated under section 106,
Whether it expanded to include that. This is what this judgment says otherwise.
the seizure which was contemplated under
Yes, you can take hold of. Yes.
literally is not possible.
Yes.
So that's why limit freezing.
Now, this may not be Karnataka High Court has said is not permissible. May I travel to paragraph number 14.
The doctor, it is not binding upon me. It has
Yes,
got the judicial value.
Definitely. But not in this judgment. Yes. Paragraph 16 now. 16. 16.
Now, entire allegation is concerning these three accounts.
Right.
Now, how the steps to be taken if these three accounts are not
May for operation is concerned, may I say with utmost respect, police have police.
I am asking you, Mr. Doctor, that if allegation is concerning these three accounts, nothing else, then how power which was contemplated under section 106 is to be exercised?
Milad
Is it possible to have a seizure of physical possession of any other items, taking note of the allegations contained in the complaint from three bank accounts? The operation of bank accounts has to be restricted to certain extent in order to facilitate investigation. If these three accounts are drained in the meantime, then what will happen?
Could I say this, Milad? cannot be arrogant until it's just moving confirmed. It are the basis of the court. Distinction. Should probably orders. The Calcutta court is distinguished. আমাদেরও তো আছে তো কি মুখার্জি না kind of always going to paragraph 16. Let's look to paragraph 16. It's in paragraph 16. How that is considered? See, paragraph 17, it's considered. And please take the last sentence, say paragraph 16. Caesar and others are same. Please come. Quote the latter is not.
So you are terming it as a prohibitory order.
Prohibitory orders. Carry on with any debit operation. I cannot issue a check to anybody. I cannot pay my electricity bills. I cannot pay my employees.
Please answer my query that if allegations are concerning these three accounts,
Yes,
suppose this prohibitory order goes
yes,
according to you,
yes,
and if these three accounts are closed,
yes.
then how this investigation will be carried on?
That will not be court. Neither should monitor nor should
At
supervise.
this stage, is it appropriate so far this court is concerned to make the investigating agency crippled?
No, not crippled. This that if that is not permitted by the assessment, whether or not that can be allowed or not. But that is what we are here for. Forget about this investigation. Executive agency, if it acts beholds the law, in which it is guided. Investigating agency is not a moment from this. So it has to work within the four corners of the statute under which it operates, so carries out its functions. So, can definitely satisfy the court that special season.
Yes.
And we look into that. Why do we have to stop us from using money now? Investigate any proceeds entering the future. That can be investigated.
জায়গাটা দেখা এটা কার order?
So therefore, your contention in the context of this judgment of Karnataka High Court is this,
Yes.
that this is a prohibitory order which is not permissible to be issued under section 106. Yes.
The judgment board of Karnataka High Court, which went up to the Supreme Court and the SLP was dismissed. Then I rely upon our High Court. Head start টা দে।
Let's start go 2025 SEC online.
Every case has its own individual facts.
Right.
So that has to be in the context of the facts involved here.
So there are certain transactions. So that is that can go to site. দে হেড স্টার্ট গ্লোবালটা দে কিন্তু আমার সাথে তো এই মিলবে না আচ্ছা খুঁজে বের করে দিস but this is reported in 2025 SCC online Kerala না Karnataka Kerala I'm sorry no, it's Kerala not Karnataka Kerala 3546 এই প্যারাগ্রাফটা মিলিয়ে দে তো আমাকে এই
Yes.
এই যে the complaint is
On what proposition?
yes on the same proposition
আমি ব্যানারটা চালু করছি কি
106 vis-a-vis the power of the investigating
the
agency.
essential facts are essential facts. Because paragraph 2 says the essential facts are as under. Malad found that.
Paragraph 6.
Paragraph
Yes.
Should may kindly turn the page. Please take me on. The sentence starting with the complaint disregard. Madam has found that, no? Second page, about 10 lines from the top.
The 11th man.
Well, it starts with the complaint in this regard filed on behalf of the third respondent.
11th
Yes,
Yes.
yes.
Third respondent led to the registration of so-and-so before so-and-so police station against the directors of so-and-so for offences under section so-and-so. In the complaint, it was alleged that out of the advance paid by the third respondent, rupees so-and-so was transferred to another entity, then extra trading, and from that account, rupees so-and-so was transferred to the account of such and such. After registering the crime, the investigating officer issued an extra B notice directing bank to debit freeze the petitioner's account. Thereupon, petitioner filed requesting such and such. Kindly take note, the section 94, that is para 13. 3. Exceeding the impending order and the direction to debit the fees of the petitioner's account, advocate so-and-so put forth the following contentions. Section 94 and 106 does not empower the police to seize, freeze. While section 94 has no application, section 106 would apply only to tangible properties which are believed to be stolen or found under circumstances which create suspicion of the commission of any offence. There is no such allegation in the petitioner's case. Now, that was the contention. Please take Millard. Taposh D. Millard is considered Millard at page 6. Now, please have a look to Millard. Taposh D. Millard's quotation.
Paragraph 12 is quoted.
Yes. In paragraph 2, to cut short, এই জায়গাটা বের করতে কোথায় আছে? Bank is the property. এই যে having considered থেকে. Yes. Now, if Lakshmi, kindly take me 4 lines from the bottom of that page.
We are therefore.
Yes. We are therefore persuaded to take the view that the bank account of the accused or any of his relations is property within the meaning of CRPC, and the police officer, in course of investigation, can seize or prohibit the operation of the account if such assets have of the offense officer is investigating into. Contrary view expressed by the Calcutta, Guwahati, and Allahabad courts does not represent the correct law. It may also be seen that under the Prevention of Corruption Act in the matter of official fine under section, so also the legislatures have provided the courts in fixing the amount shall take into consideration the amount of the value of the which the accused person has obtained by committing the offense, or where the conviction is for an offense referred to section 1 of section 13, the PQ. So, account satisfactory. The given by us in respect of the power of seizure under 102 or CRPC is in accordance with the intention of the legislation drafted in section 16 of the PC Act. For purposes, we have legislation to come to the conclusion that the High Court of Bombay, the police officer could not have seized the bank account or could not have issued direction to the officer prohibiting the account of the accused for being operated upon. So far as the present case is concerned, the order implement is already given effect to. Yes. Yes. But that was Taposh D. Yogi's view. Is parasite. Later, in Tista Atul Sitalbad versus so-and-so, the Supreme Court categorically held that after the decision of Taposh D. Yogi, there is no room to countenance the challenge of seizure of bank account of a person found under circumstances creating suspicion of commission of offence. Therefore, the question whether the bank accounts can be seized, frozen in exercise of power on 102 is integra. What can we do? Is regarding the circumstances under which the power can be exercised, one has to scrutinize. Section 102, then section 102 is scrutinized. Then please take Millard after considering 2 decisions of the Supreme Court. It is a provision that the police officer can seize any property which is either stolen under the circumstances which create suspicion of the commission of offence. Conversely, no police officer can seize any property which is either stolen the circumstances which create suspicion of commission of any offence. It has been so held by the apex court in MP America versus such and such, the relevant portion which is extracted. The police officer in course of investigation can seize any property under section 102 if such property is alleged to be stolen or is suspected to be stolen or is the object of the crime under the investigation or has direct link with the commission of offence for which the police officer is investigating into.
Now, what will happen if the proceeds of crime is deposited in the accounts as alleged?
Yes. But what is the
So whether then
Here-
what
here-
I am asking you that what is the option left open to the investigating agency?
no, with respect to the allegation that there is any proceeds of crime.
That is the mess.
No, with respect to that. Information, no. Happens that it is a
No,
proceed.
I'm asking you, hypothetically, I'm asking you that you are saying you are submitting in connection with section 102 vis-a-vis 106 that debit freezing of bank account is impermissible.
Yes.
That is beyond the ambit of section 106.
Yes.
This is the sum and substance of the judgments which you are relying upon today. But if the allegation is that the proceeds of crime are deposited in the alleged bank account, then what other option left open to the investigating agency for the sake of investigating?
The argument against myself, they can seize it. They cannot prohibit the account.
They can,
Argue against myself, they may seize it. They cannot prohibit.
to the effect of seizing the account but not to prohibit.
But before that,
I'm trying to elicit a reply from you. What is the effect of seizing the account but not to prohibit operation?
respectful submission is charge of what is there. Whatever. Not that please consider me, reconsider me, not
In that event, I have to appoint special officers to operate the bank accounts and well permit the petitioner to run day-to-day functioning only. If the operation is required.
please give me a moment. One. উনি বলছেন যে I can appoint a special officer.
Let a joint special officers be appointed. Who are the judges of this retired
Yes.
judges of this court?
We'll keep
Will,
maintain accounts.
The accounts will be under their supervision, their ages.
হ্যাঁ হ্যাঁ, two officers who's going to monitor whatever transactions are or the operations.
No policy decision, no major expenditure, only day-to-day expense.
What is the policy one and what is the?
And a report to be filed after 3 months.
Take a lead
And in the
from
meantime, court will also scrutinize that what is a development with regard to the investigation which is contemplated to be carried on.
From my understanding, it's a decision.
Because your expenditure, this joint special officers will not permit. But prior to that, I want to see the corpus lying in 3 accounts.
Yeah.
Nowhere on record today before me.
Yes.
We happen for the bank,
Yeah.
file a short affidavit disclosing the corpus lying in 3 accounts which are stated or which are indicated in the
Accounts.
My lord, may I come in here? My lord, I appear for the police.
Mr. Mehta, I will hear you. Just a
Yes,
minute.
I'm sorry. my lord.
So I want a short affidavit indicating the corpus. We are indicating corpus which are lying in the in those accounts. Yes, Mr. Mehta.
My lord, I'll also, my lord, file an affidavit. But my lord, broadly, my lord, my submission is this. I'm sorry, my lord, your lordships are not audible. Your lordships are having some other day for filing reply, my lords?
At the motion stage, and of this deputation is to be conducted on extending activity.
here.
my lord, I would, my lord, there is some communication, my lord, there is some connection issue.
My lord,
But
we can't hear.
I would, my lord, am I audible, my lord? My lord, I would request your lordships to defer the order for a few days. My lord,
No, we can't hear.
my lord, none of us can hear, my lord.
My
your
lord, we
lordship.
can't hear your lordships. We can't hear your lordships at all.
Just a minute.
দুটো সময় রাখতে হবে কোথায়
So again, আপনি Calcutta High Court please করে দিন. So you can't say that I am not bound by it. Calcutta.
Okay, can you permit me, Lord, within the time, Lord, everything gets,
Major problem lies in the account.
Lord, what, am I audible now, my lords?
Yes, then this problem has been going on audible with the.
My lord, my respectful submission is this, my lord. My lord, there is a comprehensive scheme 106, 107, 108, etc., my lord. This is seizure and not an attachment. Lord, we have conducted an investigation which we will place before your lordships, my lord, to show that the money is being siphoned off. My lord, your lordships may defer the prima facie, my lord, tentative order which your lordships are contemplating for a few days. Let our reply come on record, because this would have ramifications. Money is
Absolutely correct. The court is continuing to pass a emergency order of judges of this court for operating the bank account. Organization, petitioner organization shall be permitted to run expenses.
whether
My lord, can I, my lord, for a minute?
After Mr. Mehta, you cannot come at your leisure and intervene. We are
Let
arguing.
the court decide that, Mr. Mehta. I said
We
after
are
you finish,
arguing.
let the court decide that. You are not a judge yet.
Anyway, no, I'm never going
Let
to
the
be.
court
but-
decide that.
No,
Yeah,
but
you may
come
not want
at the
to,
last
but you are
minute
acting like a
to
judge.
mark your presence. That's not the fair thing. I'm
I
arguing
am
the
not
matter
marking my
right now.
presence. I intend to argue.
Yes, my lord, my request is, my lord, that that issue can be deferred for a couple of days. Let our my lord, written some arguments come on affidavit, and we will also address your lordships on other questions which Mr. Datta very, my lord, efficiently argued.
Yeah.
My lords, I need to assist your lordships.
Well, your lordship will give me
Well,
5-10 minutes. Well,
Mr.
please, I'm very sorry. I'm
Dr.
late.
Singhvi, your arguments are over.
My lords,
Petitioner
can I,
has
for
concluded.
respondent 4, just address your lordships for 5 minutes? My lords, I'm for respondent 4. Can I just address for 5 minutes? But, my lords,
I will
my
seek
respect,
leave to
my
address
lords,
after
for-
Mr. Call is done. After
Mr.
Mr. Call is done.
Before Mr. Call also says, well, we are not hearing your lordships. Well, I'm sorry, my lord. Let me say what I, my lord, intend to make a request.
Well, may I say this, my
My
lord?
lord, we have understood what is passing in your lordship's mind. Keeping that in mind, my lord, let us assist your lordships after a couple of days. Your lordships can, my lord, consider waiting for that tentative order, whether to pass it or not, after a few days.
How can I operate?
my lords,
Question is whether they can operate or the respondents can operate. That
Can
would
I-
also be a question.
can I, my lords, now assist your lordships?
Now, whether the court is audible.
Yes.
Yes.
Yes, now, my lords, yes, from that mic, yes.
এটা ডিস্টার্ব হচ্ছে
Yes, now, on behalf of the petitioner, now court is audible. Yes, whether the court is audible.
Yes, my lords.
Yes, my
Yes, your lordships are audible.
Now that case has been presented on behalf of the petitioners, and section 106 has been. And the point is taken that the seizure of goods is permissible under section 106. But prohibitory order within the scope of 106 is permissible. Certain judgments are true, but court is not fully satisfied with the establishment. Now, it is found that these 3 accounts are debit free. Now, if these 3 accounts are debit free, whether these 3 accounts can be permitted to be operated by the joint special officers for the retired judges of this court during the pendency of the petition. Because what is troubling this court, Mr. Mehta, I am thinking, that I have not disclosed when Mr. Doctor was arguing the matter.
that this complaint was lodged on 18 June 2006. See the timing. Complaint was lodged on 18 June 2006, and if you go to the complaint, you will find the nature of complaint is omnibus in nature. There is no specific incident, no, not any organization, any authority or any person is indicated in the complaint as accused, and there is no incident referred to in the complaint. Now, this was lost on 18th, and thereafter, if you come to page 81, FIR was registered on 18th at 18 hours. At 18 hours, and on the next day, bank is writing a letter to the petitioner that the accounts are debited. So it is cutting to the mind of the court that in what haste why this entire thing was done, and what were the materials before the investigating agency within this short span of time.
No, that material, all right, Manoj, let Mr. Dr. Singhvi argue.
Manoj,
Yes,
can
I'm
I
very
at
grateful.
some
I'm
stage?
very grateful.
So,
Let
I am
him
seeking
argue,
my
Manoj,
Lord's
now so that
permission.
he can
I am
mark his
seeking my Lord's
presence and
permission
appearance, Manoj.
to take 5 minutes.
Appearance is noted,
I know
Dr.
I was
Singhvi.
late, Balats. I know I was late. I was on my
No,
legs. We
your
didn't want to see the
appearance is
Passover
noted.
because please don't interrupt me.
Your
Balaz,
appearance is
we didn't-
noted. I'm saying something in your favor.
No, Malas, I am saying that we could not seek a Passover because it would have come late in the day. Just give me 5 minutes by the clock. I will not take more than 5 minutes, Balaz.
And
by the
Manoj,
clock.
after that, hear me for 5 minutes because I'm the
Yes,
complainant
certainly.
after that. please.
Certainly.
Manoj,
Certainly.
and Manoj, I would also.
May I, with your lordship
assist-
permission, Balaz, just say my thing in 5 minutes, Balaz. Can your lordship hear me?
Can I, Manoj, say something?
No,
Lord,
can
have
I just finish my 5 minutes, please,
Please,
Mr. Mehta?
Mr.
You can say
Dr.
what you like
Singhvi,
after that.
Cannot
You
come
can
at
say
the
after
end.
that.
No, I have made a specific question. I have posed to
Lord,
Mr.
let
Mehta
me
in the
respond.
concept of-
My Lord, we have the.
Very well, I will make my 5 minutes after he finishes his response, Balaz. Very well.
Yes.
My Lord, let him take his 5 minutes for some other professional reasons, my Lord. But for the merits, my Lord, I'll argue this.
Yes.
My Lord, we have, my Lord, your lordships have my Lord, seen certain facts. We will have to answer, my Lord, those questions which your lordships have said that it's troubling your lordships. My Lord, I'll be able to place on record before your lordships material which is gathered, which may, my Lord, shock your lordship's conscience. So, my Lord, rather than, my Lord, passing that tentative, my Lord, order today, my only request is, have it,
Yes.
my Lord, after 2 days, it can be deferred, my Lord, within 2 days. They are not going to spend money, my Lord, and neither of them should spend money. Neither the complainant nor the petitioner.
Yes, as I have indicated my mind that this court wants to see the corpus which is lying in these three accounts.
And
So
the
therefore,
expenditure.
I'll let short estimate disclosing the corpus lying in those accounts, and thereafter proceed pass an interim order.
Lord, kindly, therefore, have it on Monday. We will
What
fully
is your-
assist.
Not Monday, please have it on Wednesday, please. I'll be in
Okay,
difficulty.
Doctor, Mr. Call, have it on Monday, subject to your lordship's convenience.
At the time of giving direction upon the bank authority to verify the
Yes, my Lord, we will have to
Now,
do it to your lordship.
now,
We will have to set, please, Dr. Singhvi, we will have to, my Lord, convince your lordships. Yeah, my Lord, we have understood what is, my Lord, troubling your lordships, what is passing in your lordship's mind. My Lord, I am appearing for the police, I am not for either of the parties. Lord, therefore, we will place the material collected for your lordship's perusal, and we'll also address on the legal question. Lord, some judgments were cited. There are some other judgments also. Lord, so let that happen, my Lord, Monday or whenever, my Lord, your lordship considers.
Now, Malas, I'm now pressing for my 5 minutes. Your lordship may do whatever the date is. Please allow. Now, Malas, I first of all apologize that I was on my legs. I couldn't come. My learned friend Malas is unfortunately habituated to making comments with ulterior motives about other people. I will not indulge in that.
Not
Now,
others,
Malas,
others.
I want to say 3 or 4 things, Malas. There are 4 or 5 points very briefly. And I want to Malas, put it squarely before your lordship for the larger consideration. There is, of course, a consideration of section 106, 107, which my lord has noted. But the larger consideration is this. Point number 1, Malas. The issue is that where Malas a level playing field and a political party and political associations under Malas Article 19.1a, 19.1d are the basis of democracy, which in turn is the basis of Malas basic structure. Can Malas, the larger issue is this, can a friendly police force paralyze a running party by freezing its lifeline, all funds, and rendering a level playing field non-level by the simple expedient of freezing. That is the larger public law issue, point 1. Point 2, this implicates 4 articles, 14, 19(1)(a), 19(1)(d), and 300 capital A, which is also a constitutional right. Number 3 is important, the point which my lord adverted to briefly. I said, can a friendly police force paralyze a running political party? On 18th of June, there is a complaint. I will show the complaint. It is the most delightfully vague complaint with not a single fact, which can lead to any action. It can't lead to an FIR according to me. On the same day, with amazing alacrity, on 18th June, a FIR is made. And the impugned order is passed on the next day, which my lord has noted. It completely blanket freezes all the accounts. Now, it is true that the party whose accounts are frozen has lost in the elections. It is also true that it has suffered depletions in its ranks. It is common knowledge. At the end of the day, in a democracy, in this particular case, the difference between the winner and the loser is 4 to 5% vote share. Does it mean that if you have the Mr. Mehta,
Yes, sir, you are not giving
allow
a
me to make my
political
relevancies.
speech.
You can't
You are
digress
not
this.
giving a political speech.
The losing party cannot be paralyzed like this by use of state machinery on a mere complaint, immediate FIR, and complete blanket. Now, just wait for a minute, brothers. Kindly consider this. Both factions of the party will go to the election commission and decide which is the real party. Both factions will fight in the courts as to whether this is exempt from the defection law or not. Otherwise, one group will be defected and expelled or excluded. Before the election commission decides, before the courts decide, the police has decided. The police has decided that one faction at whose behest the complaint is made, the complainant is a sitting MLA who has gone to the other faction.
The court is not entering into this issue. Court is considering the validity of the orders for freezing of accounts.
So that's your Lordship is right. This is the larger backdrop which has implications. That's all I'm saying. Now, let's just see that narrower issue which my lord is saying. Please turn to the complaint at page 41 to 42. It has 3 remarkable words: reliable circumstances, surrounding developments, serious and credible inputs. Nobody, even a professor of English language or literature, could not have written better delightfully vague phrases. 3 phrases at page 41 to 42. Yes. And then it says, they disclose a reasonable suspicion regarding commission of cognizable offense, regarding the generation, routing, and possible concealment of funds. My respectful submission is, and a question to myself is, in a normal case without all these overtones which we have in this case, would your lordship consider this even fit for an FIR to be registered, much less an immediate action of blanket freezing? That's all there is. There is reliable circumstance, surrounding developments, and serious and credible inputs, which disclose a reasonable.
Consider whether the FIR can stand or not, and consider the
No, I'm only on the prima facie case. Well, absolutely, my lord is right. And the prima facie case, why your lordship needs to pass an interim order of some sort, I'm only making that good. It's a strong case where your lordship needs to give protection. Otherwise, the thing is paralyzed.
Read a specific question to Mr. Mehta that what were the materials available to the investigating agency to act in such a hot haste that on 18th this complaint was lodged and on 19th Bank Authority was writing to the petitioner that your 3 accounts were debit frozen. Now, what was the materials which are available?
Yes.
That and wants to examine, but today before that, what the court wants to see that the corpus which are lying in the accounts that the court wants to consider. So therefore,
and the narrow.
My lords, can I now?
Your lordship was suggesting, subject to my lord's kind discretion, that your lordship will have an independent agency overseeing the account. That need not wait for Mr. Mehta's intervention.
Let us
1 minute, sir. 1 minute. Follow your own advice on not interrupting.
Yes.
My lords, your lordship was suggesting that your lordship will have an independent body for the time being. That doesn't have to await Mr. Mehta's response, is my first submission. The other aspect is, my lords, ex facie, textually, as your lordship has already been told by Mr. Datta, doubtless. 106 is not attracted ex facie on the text. 107, if at all, will apply, which requires magisterial prior intervention.
This is all argued.
These
my
are
lord.
constitutional grounds and statutory grounds, both. Malas, the matter is of very overwhelming prima facie nature. Your lordships could consider some kind of an holding order which is fair to both sides. The discretion is my lord's, but a fair order for both sides, where Malas, the other side does not have this complete freeze.
Yes, respondent, right respondent, the de facto complainant, what is your contention?
Yes, my lords, my respectful submissions are twofold for your lordship's kind consideration. I am the complainant in the matter. My lords, my first serious objection is to the very maintainability of this petition, because these people claim to represent the Trinamool Congress. Now, according to us, the National Working Committee's tenure as per the Constitution of 2011, which is the only constitution recognized by the Election Commission, came to an end on 11th of February 2025. Thereafter, 220 delegates got together on 22nd of June 2026, appointed office bearers, National Working Committee and All India Committee, which are provided for in the Constitution. Now, before that, what some people have done is that by way of a website update on 5th of June, they have unilaterally appointed various office bearers, which they had no authority to do so. Now, my lords, really, as your lordships are well aware, under the symbols order, under the Constitution of India, all these issues...
But Mr. All, taking note of the complaints, the complaint dated 18 June 2026, whether these issues are required to be running to.
Sorry, my lords?
Taking note of the complaint dated 18 June 2026.
Yes.
Now, whether these issues are required to be running to the dissident groups may fight out their own cases in order to assert their right.
No, my lords, can I...
Political parties concerned.
Can I...
They has to consider on the anvil of the complaint lost on 18 June.
Can I, Manoj, can I just complete my submission? My only submission that I am bringing to your lordship's kind consideration is this, that who represents the party will ultimately be a question decided only by the Election Commission of India, as your lordships and the Supreme Court have held in any number of judgments. Who represents the party? These are rival factions within the party, as we are talking about. And the Election Commission is duly equipped to pass even interim orders during that period, and that is within the power of the Election Commission. Our serious objection today is, my lords, why the complaint was filed is, if a faction is trying to route illegal transactions and money into accounts, tarnish the reputation of a party, there is an offense which the investigating agencies are looking into, as the Solicitor General said, and he needs to place, as he said, certain material before your lordships. Our objection today is, my lords, that can a person today get up, and on whose authority does he say that he represents the Trinamool Congress? Because we are saying there are rival factions. If there is no authority in law to represent yourself as the party, how is the petition maintainable? Your lordship...
Whether that issue, that who is the actual Trinamool Congress among the dissident groups is not before me to decide.
Right, but my lords, the petition is before your
So
lordship.
Don't expand don't expand the scope of the petition.
No, my lords, my respectful submission is that I'm not for a minute saying that
there is no whisper in the complaint dated 18 June 2026 to that extent.
No, my lords.
That the present signatories, so far these three accounts are concerned, are not authorized to operate that.
No, my lords, my respectful submission is, I'm not for a minute suggesting that your lordships will decide who the real Trinamool Congress is. I'm not saying so. In fact, I'm saying that is to be decided by the Election Commission. All that I'm saying is that a faction which has no authority in law under the Constitution today to represent the party is filing suo motu petitions. Surely we are entitled to object to the very maintainability of the petition.
Your complaint does not instill confidence in the minds of the court. It is a complaint omnibus in nature. There is no pinpointing that which authority, which organization, which person was responsible for draining money, getting the amount to the bank, to those three bank accounts.
May I, with respect,
and what was the relevant date on which this malpractices took place, which concerning the three accounts, these were not indicated.
My lords, may
So
I
therefore,
with respect say,
foundation of the criminal prosecution, that is not very
my
strong.
lords, may I with respect answer that question, my lords? Your
Yes.
lordships have time and again said, my lords, that ultimately at this stage of quashing, mini trials are not conducted. What your lordship sees are three crucial things, and that is that the defense which the accused is putting up is of sterling and impeccable quality. Now, the investigating agency and the learned Solicitor General has said is looking into it, and disturbing facts have come to light. Now, surely if those disturbing facts are placed before your lordships in the next 2 to 3 days, what is it that the accused today has placed before your lordships to say that this is a case with ex facie? The complaint should be quashed if the investigating agencies are looking into it.
They have to know how to protect his client and what submissions have to be made. So I want to know that what is your contention with regard to the nature of complaint.
So, my lords, that's why we are saying people who do not even represent the party are filing petitions. Let people at least file in 2 days their respective affidavits raising objections from maintainability to the solicitor, bringing to notice the
which I am not calling.
No, my lords, but surely a petition which is not maintainable in law cannot be the basis of any order being passed. Our preliminary objection is that the petition is not maintainable.
The pray for time to satisfy this court with regard to the materials which are available before the investigating agency prior to directing the bank or the debit freeze those accounts. I will
Surely, my lord.
Yes. Court also wants to know or wants to find out the purpose which are lying.
Right.
So let
Lord, can I have 1 minute? Can I have 1 minute? Can I have 1 minute?
Your lordship should know one fact.
Can I have 1
This
minute,
same
my lord?
person, the complainant,
Yes.
took money
Yes.
along with his colleagues from the same account
Yes.
till about 10 days ago prior. Therefore, the
can I
accounts
have-
were all kosher the whole
Lord,
of May and June.
No, my
Suddenly,
lord,
they've become
I-
tainted.
can I-
across the
can I
bar,
have
you
1
can
minute?
say what you
Using
want.
these funds for elections.
Across the bar, you can say what you want. These are serious
No,
illegal
it's a fact.
transactions and
Your
looting
person
of
has
illegal
taken money.
money.
Lord, can I have 1 minute, my lord,
Official.
after this cacophony? Well, can I have 1 minute?
But this is where, as your lordship goes,
Mr. Datta, can we?
This is for election campaigning.
My lord, can I have 1 minute, my lord? My lord, my concern, my lord, I will just share with your lordships. And your lord,
After declaration of election result, things got changed.
my lord, am I audible to your lordships, my lords?
He's saying about the fraction and all that.
My lord, am I audible to your lordships?
Yes, you are clearly audible, Mr. Mehta.
Yeah, yes, my lord, give me only, my lord, 1 minute or 2 minutes.
Yes.
My lord, what is my concern?
Because 5 minutes of Dr. Singhvi, only 1 minute. Yes.
No, Dr. Singhvi's 5 minutes, my lord, has some multiplication factor, my lord. It's not with me. My lord, I'll just tell your lordships, my lord, what is my concern as an investigating agency. My lord, now, whether the complaint mentions or does not mention, one thing is clear, even Dr. Singhvi says there are two factions claiming to be a party. Now, my lord, suppose your lordships were to pass an order which your lordships are tentatively, my lord, persuaded to pass, that some independent agency would decide whether to disburse money or not. My lord, kindly imagine a situation or visualize a situation that the president of the party claiming to be the Trinamool Congress and another president of the party claiming to the Trinamool Congress both go to the former judge and say that we would like to my lord, withdraw this amount. My lord, we will have to consider this and assist, my lord, after taking into consideration all, my lord, possible scenarios so that the order is workable. Order does not become, my lord, unworkable, because neither, as your lordships have rightly said, your lordship would not be able to decide which is the correct. Only a minute, Mr. Datta, you never do that. I know that you, and I have a very high respect, my lord, for Mr. Datta. My lord, your lordships obviously cannot go into that question. Obviously, my lord, the authority, my lord, independent judge, or that also will not be able.
Second, your 1 minute for a second, Mr. Mehta, considering the contents of complaint with 86, whether court is required to suspect.
But now, my lord, even complaint says or not, it is an admitted position. Dr. Singhvi also says that there are two factions. So, my lord, allow us to consider that.
Well,
Sir,
two fractions will be decided by the EC. This freezing order is prior to the decision of the EC.
Mr. Mehta, if just the rights of two dissident groups, two factions is not before me.
No, your lordships have rightly said that my lords would
My
not
lords,
go into it.
And even we
But
have not
this-
argued that. Even we have
A
not argued.
retired
have not
judge
argued.
decides much more difficult questions. Well, a
Only a
retired judge is
minute.
fully competent to decide it. He's not going to be disabled deciding such simple questions.
No, no.
Your lordship is not suggesting, your lordship is suggesting an equitable way out,
Not the only
fair way out.
problem would be, my
a
lord,
viable way out.
if two fractions, as per the petitioner's own admission, go before that honorable judge and say that we want to withdraw this amount, my lord, how would that judge also would be able to decide whom to permit? My lord, therefore, let us conceive, my lord, some workable order, my lord, which your lordship
This is to be
can
decided
pass.
either by the ECR or by the Speaker in the Assembly. This
I
cannot
am
be
not on
referred
that,
within
my
the
lord. I am
domain of the
sorry, my
police.
lord. I am not.
Brothers,
I am not
if
saying
you
that.
are operating a bank account, what will the police?
There has to be a workable solution.
No,
No, therefore, my lord, what I am suggesting is, what I am suggesting for your
Who's
lordship,
going to operate which account?
Mr. Datta,
The
please.
other faction cannot be
Mr. Datta, please, only a minute. My lord, what I am suggesting is, till your lordship, my lord, let us have, my lord, our inner
openly compromise the
Arre,
police
please, sir, please.
in investigation.
Friend, 1 minute has
Please,
become
sir,
10
let us
minutes
not
already.
make it a political.
Is
Lord,
1 minute has
what
already
my
become 5
suggestion,
minutes.
right now, none of the factions should operate and let the account remain frozen. Mr. Datta, please. You obviously would not agree. Let
Let's-
the bank place before your lordships, my lord, the corpus within a day, within 1 or day, 2 days, whatever days, my lord, your lordship considers. We will also place on record, my lord, what has happened with the corpus, how it is being siphoned off. My lord, we have the material to show to the lordships. And after that, your lordships may pass an order which.
No, but where is the chance of siphon of corpus? Because if these accounts are covered by joint special officers for the retired justice office.
Yes.
Well,
Mr. Mehta is arguing more than the complainant. Mr. Mehta is arguing like the complainant. How does the police have a problem if a retired judge looks into it?
Yes.
Mr. Mehta is a police force. How can he object?
I understand.
He's like a complainant, Balaz.
Whether-
Worse than a complainant.
My lord, I am
Whether the
not.
order which the court is contemplating to pass on.
Continuously arguing like a complainant.
Lord, I'm sorry, Dr. Singhvi, please.
I'm
You are
asking you,
extending your
that the
minutes, that's all.
joint-
Nothing turns on that.
Officers are appointed to operate the bank account, then where is the question of siphoning of the money?
Lord, my difficulty as a police force, Dr. Singhvi didn't understand my argument correctly. My lord, difficulty as a police force is, suppose two factions go before the learned judge and say that permit us to operate the account. One would say we are the real party. Another would say we are the real party. Lord, as your lordships cannot decide, that man, the judge also cannot decide. Therefore, my lord, let us have an
What is the
order.
police force
Which is,
concerned with that?
please,
Balaz? Why
Dr.
should the police
Singhvi,
force be worried?
please,
Why
Dr.
should the police
Singhvi,
force be worried? They
please,
can't decide.
Dr. Singhvi, don't make it a political speech. I
No,
understand
no.
dual capacity.
You are the one who's acting like a
So, my lord,
complainant, Mr. Mehta. I'm very sorry. Worse than a complainant.
Anyway, I ignore you. But, anyway, but this is my request, my lord. Kindly pass an order which is workable. That's the respectful submission. And within 2-3 days, my lord, nothing is going to happen. My lord, it's not nobody's case that we have to pay something tomorrow. Either of the parties are not saying. As
Why
a
day-to-day expenses? What does it mean by notification?
Of course, we are saying, Balaz, and the whole thing is paralyzed. It's paralyzed.
All that we are praying is let our very brief replies come on record in 2 days, and then your lordship can pass any appropriate order.
In presence of senior state respondents. Detective opponent being responded and HDFC Bank being responded. So, learned councils, because parties have made their submission. And at the motion, next factor, at the motion stage, a four-way conflict pass and into order subject to hearing of the so, however, before passing On
Court.
It's a HDFC Bank, Central Plaza branch. Last page. So, Central Plaza, 2x6.
Page 84.
Page 84, right hand side top.
Lying in HDFC Bank Limited, Central Plaza, HON'BLE. Next paragraph. Branch manager of Central Plaza, HDFC Bank. Branch manager of Central Plaza branch, HDFC Bank, is directed to file the shortage. This is the corpus line in aforesaid by Tuesday next. By Tuesday next, 7 July 2026. List the matter at the top under the same heading on 8 July 2026. Monday will be the holiday. Next paragraph. Mr. Mehta, the Solicitor General of India, representing the state respondents, has also paid for accommodation to place materials which are available before the investigating before giving direction about the concerned medical debit is bank accounts. To enable the investigating agency to place relevant materials, hearing is also adjourned. This is the matter on 8 July 2026 at the top under the second. No, nothing. Nothing. Come back to the
Grateful. Very grateful.
Wait, that's why I have placed the matter at the top on next Wednesday. Please come. And there will be 3 intervening all try to appreciate also the situation.
Lord, grateful to your lordship.
Very
Tomorrow,
grateful.
They
Very
will file an affidavit by Tuesday and come back.
Lord, grateful.
Very-
Lord. It was
very
a pleasure assisting your lordship. Lord.
Very
Grateful.
grateful.
Yes, yes. Yes, affidavit of service. Affidavit of service filed on the petitioners. Since senior advocates are not there, one thing also drafted is the advocate general that if joint special appointment and if two dissidents to the joint special so that this order will not be an unworkable order. Then the joint special officer will be difficult to decide whether it is expedient to permit to operate the bank account or not.
Who has the right to operate? Show that the effect of complaint is raising this issue. Police
No, Mr. Mehta is submitting.
Mr. Mehta cannot make this submission. How is he concerned about movement? operate the account. This is actually a legislative issue and an ECI issue.
If there would not have been any decision, then question. In the presence of the accident group, then it will leave a very difficult situation to handle so far those transfers. So court is also rethinking it.
Because so far as the operation of the or let us start from the beginning. When you are doing the bank account, then we have to see this the bank can only change at the instance of the parties who have been in the account that from tomorrow it will not be easy. Otherwise, because whoever is operating the bank account, they do not use their right to operate the bank account simply because there is a discipline. This often happens in families. After the death of, say, the father of professor. No, this is not a company. This is the body of individual. Under 21 year of the representative of the respected company. Company is a separate state.
This state or whether this question, and why did you not find this out?
Something says the police will be held responsible if it doesn't take no. This is not within the domain of the police. And with respect, your Article 19 applies in case of political parties.
Whether it is within the domain of the police authority or not, that I have expressed in my conflict the complaint lodged on 18 June 2026. But court is thinking that if joint special officers are appointed and before they do groups appear and claim that they have a right to get
The joint special officer, you can respect. You are not confer any jurisdiction on the joint special officer, which the police in its investigative capacity doesn't. The purpose of appointing joint special officer is to ensure that the so-called proceeding is not proceeds or whether it is not taken away, does not get dissipated, it does not get diverted, etc. Therefore, the joint special officer allied to police cannot decide even if it will not be dissipated. The only question for the joint special officer, whoever are operating the account or is because affidavits and declarations are to be filed or are on record with the HDFC Bank as to who are the authorized who are the persons to operate. Apart from that,
those principles would also apply. Sure.
Disputes are that what valid in some political parties and say that how do you get question why do you not say right? That has operated, I cannot allow this account to be operated by X, Y, or Z. I cannot say. The bank has simply complied with the notice of the is whether the police had responsibility that to experiment whether that is possible. No, the bank is not obliged. Bank is only because a custodian of the property of others, nothing else. Bank has got no right. Even if it is a stolen money, I put it into my account. How can the bank say that stolen account? But this political is the wife of the she accommodated persons and retained the petitioners and take some money out of one of the respondents, especially the respondent number 11. He claimed he is a member of the Maharashtra jail and he demanded money and also ransacked. What you are paying for? For my lord, I complained to the police to take at least some action, my lord, at least to take some action. At least. Register.
The part of the police authorities in taking steps based on the complaint lodged. In a paragraph, however, now representing the state respondents has filed a petition dated 2nd July 2026. Officer in charge of Prakash police station, Bharat division, Kolkata police. Disclosing that based on complaint lodged, complaint lodged, Prakash police station case number 2026. Registering complaint, grievance stands with this. No further order need be passed on this writ petition. However, already directing the police authorities to expedite the petition stuff. A writ petition stands disposed of again. Only to as per the senior citizen, that was also as per senior citizen, take some steps. I have the representation through representation. I have approached, but my lord, and also also it will also be at liberty to take steps to experience at 2007 by approaching the jurisdiction of it. If the copy of the petition is made representing the petitioners. I don't. Is the appeal for the petitioner? Well, the petitioner, before the lordship of the petitioners. Number one, he's aged about 75 years. He's the councillor from the KMC for 3 terms and was the member of the mayoral council of the sewage and drainage department and various others. So for a very long time, he was the councillor of a party which is presently not in power. His son, he's 49 years, is also a councillor of the KMC. Now, suddenly, after the change of the regime, a case has been foisted against him. But if your lordship kindly sees, why does he not party? Well, yes. Ask for disclosure. Party will come back. Look, we have also asked for disclosure. And de facto should be. Give the de facto only for us to make up. Your lordship asked an order where your lordship had passed a wrong order. That no orders can be run unless they are decided about or set to be wrong. For internal protection, one thing issues from the state that they shall not. Why will I not? That cannot be passing any order. Assurance, lordship, the assurance officer of the ship some value. Because I only one second. In order to 35K unofficial beyond 7 years. Let me finish. Because extortion has been alleged. That kindly see. Before the kindly see the letter of complaint. That is what. Yes. 35 is the letter of complaint. It is the first information. 35. I perhaps cannot appear in this matter, but based on this prosecution initiative. If I was registered, yes, we oppose. So we oppose for having pushed up the power. Already got take a tower location. I am giving that. All location is exact location of power tower সাথে ফোন কানেক্টেড সেটা বলবো সেম টাওয়ারের সাথে কানেক্টেড দেখুন হয়েছে ফোনটা দেখো সবচেয়ে টাওয়ার টাওয়ার ওটা ক্রিস কোর্স করা হবে টিজার করা হয়েছে এয়ারটেল কোম্পানি আর এখন Doctor. It's today, 17th of June, 2026.
Lordship, kindly see the paragraph, Lordship. I had early, I. So that is kindly see the page number mark করা আছে?
এটা একটু দেখে দিন কোথায় কমপ্লেনটা।
একটু কমপ্লেন।
আরে
The CD.
কমপ্লেন যেটা শেষ করেছে
CM and Mayor.
এরকম মনে দিন।
Lordship, please to complain.
month of February. Was it 17 is 18 present complaint. So normally complaint before the Kolkata Municipal Corporation. Considers. It is the Kolkata Municipal Corporation a competent body to allege and we don't have to this matter. Well, kindly considers whether the KMC is a competent body to whom this complaint is to be made. But the competent body with great respect I submit to the civil courts. If I am on side constructed, that is any and land which is constructed, it's an illegal construction. I don't know. You can understand. No, that's from 2017.
Lordship.
If I am submitting, I cannot submit. My learned friend will have an opportunity. Kindly sees this is an allegation which is made in 2026 of an incident of 2017. Now, what stopped them from approaching the civil court? To the civil courts. Property mentioned. Even that is so, if that is so, that's a case of criminal trespass. That's below 7 years. If sections are claimed, which is criminal trespass, 7 years. 308 subsection 5. This I said is not ruled out. 308 would be only above 7 years. 5. 3085. 115 is her, which is again equivalent to 323, which is below 7 years. 34, it's not A. And the
and 27 of the outside, that's also 7 years. Now the only thing of 7 years is 308 subsection 5. Now kindly see section.
and my house is completely covered with CCTV footage, police will deliberately not go and collect it and show the falsity of that allegation. They will speak of this tower location. Tower location covers at least around 1 kilometer. That person and be punished to the president of this. Can you see subsection 4? To that person or to any other shall be punished with imprisonment which may extend to 7 years. Now, in their FIR, they say that I had put pressure upon the him to get 10 years. He agreed, but did he pay? That is the definition of extortion. Whoever actually puts any person, that's subsection 1, in fear of any injury to that person and thereby dishonestly induces the person so put in fear to deliver the person property or valuable security or anything signed or sealed which way commits extortion. So extortion is completed when there is when the completion of delivery. Clear line. Here is the case now, it is not so I made a even if I accept everything, I have made a threat. He has not complied with that. Otherwise, he becomes the 6 at best. Criminal intimidation. Which is again a non-offense below 7 years. Okay, one thing more, Miller, if you have the complaint, I don't know the date thereof which was made, but it does not find any mention in the FIR. If they have made the complaint, it is not being mentioned in the FIR. Definitely FIR need not be an encyclopedia fact, but they are mentioned about various other things except that complaint. How many cases are there? Therefore, I will disclose that. I have also prayed to disclose that. But as you all understand, after the regime change, there has been a attempt to implicate persons of a different political personality with cases after cases and put them behind the bars under any circumstances. I say this is a bona fide attempt to obviate section 35(3), deprive me of that protection in law in order to take me into custody without taking recourse to that by putting in any section. And I am ready and willing to hand over the CCTV footage of my house itself. What the purpose of the subserve by taking the petitioners into custody? Custody. If submit. There is a possibility of taking into custody. Section which provides what is the charge in custody? The state minister. To take those tower locations
Tower locations are. From the tower location, the exact location cannot be fixed. Tower the phone is connected to that can be fixed. Now, the distance is and the company
So Das, where is it? So far the letter to the chief minister. Where is the investment? Subsequent steps were not taken. If a representation was, if the representation was not taken into consideration, at least a writ petition could have been filed before this court. Lordship, now what the company does. So why, but in the meantime, no steps shall be taken with regard to affecting personal liberty of the petitioner. Lordship, it's my case, Lordship. I am sending the confidence, Lordship. Why the I cannot say. I have the petitioner to make the petition carried out. Lordship, court will hear the complaint. Lordship had asked why is submission that no steps to be taken against the petitioner. Constitution cannot. I would feel that there is something. Page number 36 of the petition. Said after 17th it happened, 17th is the complaint. Incident happened on 17th concerning an incident land is taken. So to the residents of the petitioner just after that incident. Should the campaign highest officer of the state and no action is being taken, the company the accused person is multiple of occurrence. Standing there, asking what the that is not. Has to be people worship. At least person made a complaint. The accused person nothing is out of
Well, this complainant is of Dom Nager Bajar. And 32 your lordship will find. Come on, as party. Complaint has to be party, so petition court has to hear. Only that's why I am ready to cooperate. My house has all the CCTV footage. The police will not take it. Because I am a person who is of a different political persuasion now.
It's no politics involved. Before the couched as political vendetta. It cannot be couched. Then it is also a fact that we use the political muscle power and well, and how did the deeds have been seized, lordship? How did those get about the complainant? Any deed in my name or in the name of my son. So a land grabber so absolutely legal. That is the question of investigation. That has to be investigated. Below 7 years. What is probably that on 9th April 2022, at least before the concerned authorities to the chief minister as the honorable chief minister, as well as municipal corporation. Look, I think I am question but he considers what is the material against me that I have criminally trespassed. Offense of extortion with and small assessment of 7% does not have the land someone run to his head and say that I deliberately coming to my house. Now then the CD, then investigation continue. And I made him a coming deliberately to my house to get threatening. Then you have to square house or deliberately even says about party political power. I do not have that right. He's still the councillor. I need a councillor. 17th of June, come to my house to get threatening. My instructing officer says if should kindly by presenting this affidavit of service filed on behalf of the petitioners taken on record by next paragraph, by presenting this writ petition, petitioners have questioned propriety of FIR it's 1 yes. FIR, formal FIR. FIR. Bihala police station. Case number 160/17/2026 and validity of criminal prosecution initiated based on such FIR. Stop. On behalf of the petitioner, attention of this court has been drawn to 35 of the writ petition, page 35 and 36 of the writ petition. Containing complaint with 17 June 2026 by one Jitendra Singh. Jajender's right, by one Jajender Singh. Alleging land grant, destruction of
by the petitioner, by the petitioners. Stop. By the petitioners in 2017. Stop. It is contained on behalf of the petitioners by Mr. Ganguly Lines Senior Advocate. An incident of 2017 was brought to the notice of the concerned police authority for initiating a criminal proceeding after change of political dispensation on 4th of May 2026, the date of declaration of assembly election result. Declaration of assembly election. Stop. It is also submitted that petitioners, father and son, they of councillors and are councillors of Kolkata Municipal Corporation. Stop. It is content of the political vendetta. Complaint was lodged precisely 9 years after and next paragraph. On the contrary, Mr. Das and additional representative representing the state respondents has opposed this petition. And before this for consideration. It is submitted that there were continuous contemporaneous representation made to the concerned made to the concerned authority of Kolkata Municipal Corporation as well as the then Chief Minister by the de facto complainant, which could not yield this. Stop. Next paragraph. Submissions made on behalf of the parties. At this stage, the complaint was lodged in 76 concerning an incident. Incident of 70 itself. But threatened intimidation happened on 70 itself. Kindly tell page 36 of the requisition, Lordship. আচ্ছা ওর যেখানে সাবমিশনটা করছিলাম ওখানে একটা অ্যাড করো that today at around 7 done at the that happened on 7 and he goes to my house. I have not even asked him to that the record. Yes, that is what you said. Today I went. To his house. It is also contained on behalf of the state respondents. Statement initially allowing that the incident does not confine to land grabbing in the year 2017. But complaint was threatened on 17 June 2026 by the petitioner number 1 using his gun. Stop. এবারে তুমি আমি যেখানটা বলছিলাম সেখানে ঠিক আছে তো শেষ হবে এবার complaint dated 17 June 2026. Disposal or incident against done on 17 when residents of the petitioner, residents of the petitioners. When petitioners. Stop. Next paragraph. Also discloses the fact that from the time at the time of petitioner gone. Stop. Yeah. Taken upon by the police authorities along with any content that thereby granting protection to the petitioners. Question would arise as to why complainant takes subsequent steps in 27/2018 when concerned authorities could not yield result. Stop. Next paragraph. Considering circumstances centered around aforesaid complaint and the criminal prosecutions initiated, finds it apt to rely upon judgment of the Honorable Supreme Court reported in 2024, 15 SCC 776. Haji Iqbal alias Bala. Others. In paragraph 14 of Haji Iqbal Sutra, it was succinctly held by the Honorable Supreme Court that it will not be just enough for the paragraph. Okay, we got the first portion to read. Next paragraph. Primarily, it is found that the complaint of the petitioner is linked to an incident of 2017. Court directs the concerned police authorities not to take coercive steps against the petitioners of the court. Our investigation shall be carried out in accordance with law, and petitioner shall cooperate with the investigating agency. The petitioner shall comply with the notices issued by the investigating agency. Stop. Next paragraph. In the event petitioner does not cooperate with the investigating agency, leave is granted to the state respondents to bring it to the notice of the court. Stop. State respondents shall be at liberty to pay for vacating if situation so arises. Next paragraph. Learned advocate for the petitioner amend the cost title in proof of this day and add complainant as additional respondent. Stop. After such amendment is carried out, learned advocate for the petitioner is directed to amended copy of the petition and order passed today upon the additional respondent by service to be filed on the next date.
Only in addition to that, may I also pray for the relief as provided in prayer A at page 23, prayer B, I'm sorry. Prayer B at page 23, that's the list of the other proceedings, if any, which has been initiated against.
Next paragraph. Have you moved party?
Yes. And will head him also if your lordship so.
Or it is under the jurisdiction of or the police.
But as your lordship knows, this is a situation where it can even be started at going low too also. So
is one party, but whether it will be possible for him to appraise, Lordship may give a direction that a report may be provided by the DIG
Prosecutions pending against the petitioner apart from the criminal prosecution, which is included in this prosecution. Next paragraph, Director General and Inspector General of Police West Bengal. I choose by fortnight from date, intimate whether in other prosecutions are pending against the petitioner, except prosecution which is state, which is included in this petition. Come to the would your lordship be considering this? Then I can hand over a copy. If I were leaving, paragraph 14. Oh, it's paragraph 14. Paragraph 14. भूल करो ना. Action. भूल. Paragraph 14. देखो. हम लोग पढ़ने लगते हैं. Please, please. Now the next matter, for my other side.
Item number 35.
For the petitioner, my lord.
APF of the private respondents.
Yes.
Private respondents. State has to file a report.
Who is for the petitioner?
My lord, I am for the petitioner.
Just a minute. এসিটা চলছে না তো চলছে তো একটু ইয়ে করো টেম্পারেচারটা একটু কম report.
Lordship, I've handed over the.
What is the matter about?
Lord, there was an agreement made between the parties, my lord. The opposite party was supposed to, my lord, pay some consideration amount for a go down, my lord. There was an go down, my lord. My lord, I was developing a property. They were supposed to buy a go down in that property, my lord. There was an agreement made, but they failed to, my lord, meet the terms and conditions of that agreement, my lord. Eventually,
File a suit for specific
my
purpose.
lord, not that matter. I'm not in that, my lord. My lord. Thereafter, my lord, the agreement got lapsed, my lord. I'm on that. Thereafter, my lord, on 11/2/2026, the petitioner was obstructed and he was, my lord, hit by a blunt stick. They were trying to grab the property, my lord. My lord, I'm on that, my lord. My complaint was on 11/2/2026, my lord.
এইটাকে ঠিক করাবে আমি কালকে কিন্তু দেখবো A long-standing dispute. Previously, a complaint was lodged in 2015. The prosecution was initiated by registering FIR,
Lord, that
and
was-
this was ended with specific that mistake of fact. Subsequently, there was a further investigation in connection with 2015 proceeding, and the result was same mistake of fact. And thereafter, another complaint is lodged in 2026.
Lord, that was
Now,
against-
with that complaint also, there is some issue. The issue is the complaint was made by email. Now, police
Made by?
made via email. Lordship will find that at page 39.
Yes, without signature, anything.
No, signature in the attachment, it is there. Now, Lordship, as per 173(1)(b, it has to be, even if it is sent by email, it has to be signed. A physical signature has to be there. Now, my lord, if my lord
Is
kindly
there any
takes-
specific provision to that extent?
Yes, Lordship, 173(1)(b. If it is sent by electronic means, then signature has to be obtained within 3 days of receipt.
173(1)?
1B. A is orally, B is in case of within 3 days of receipt of the email, it has to be signed.
On being signed within 3 days by the person giving it.
Giving.
173(1) II. Not B.
I
Yes.
apologize. Just recollecting from memory.
Yes.
So what now, if Lordship kindly takes my report, the fourth last paragraph, which begins with inquiry, revealed that the last line, it is pertinent to mention that the petitioner never come grammatical
Physically.
error physically at Maniktola police station. Now, without that, although Lordship at page 38 will find that there is a signature of Amitabh Dev Bhomik, who happens to be the petitioner, but this signature is in the form, is an electronic form, as an attachment to the email. But a specific
But
signature
one, requirement under the 173(1) II is not compliant.
not complied.
That has to be done only when the formal FIR is registered on
No,
top.
no, there is a long-standing dispute.
That is
Previously, your attempt failed.
that is the
Prosecute
ground.
the private respondent.
And that to FRF,
That
not
is-
even
that is with
FRT.
respect to another accused person. Now, with respect to signature, my lord, that will be done only when FIR
I am
is
not on
registered.
signature. I am on your conduct.
My lord,
2015 proceeding was initiated that ended with mistake of fact.
my lord, this is the
Mistake
conduct.
of fact, subsequently, subsequent further investigation that also yield no result because it was also reported mistake of fact.
My allegation is that the agreement of 2013
File
is intended to be.
File a suit for specific performance of contract.
He need to file, not me. He need to file. He is intending to enforce the agreement of 2013 in 2020-26 by not paying the entire consideration money. And when we are preventing him, reporting the concerned police station, he is showing the powerful.
I don't want to advise my learned friend, but then he can take a point of limitation if he wants to enforce the 2013.
Affidavit service filed on behalf of the petitioner. You need not open your mouth. 6 and 7.
Yes.
Yes. Affidavit service filed on behalf of the petitioner is taken on record. Stop. না affidavit service আগেই ফাইল করেছিল মনে হয়, দরকার নেই, কেটে দাও. Matter is heard in presence of the learned advocates representing the petitioner, state respondents and respondent numbers 6 and 7. Stop. It is contended on behalf of the petitioner that in spite of lodging complaint of cognizance was not taken. Cognizance of the complaint was not taken by the concerned police authorities, prompting the petitioner to approach this court with a present writ petition seeking necessary direction, which would lead to initiation of criminal prosecution by registering FIR. Stop. It is submitted that dispute relating to development agreement.
I being a promoter, I am saying that the intending purchaser is trying to enforce the agreement of 2013. When I am preventing him, he is looting my raw materials lying over there. In this respect, I have made complaint. Police
Trying
is
to
not
take
taking-
building materials.
My lord, building materials, fitting the contractors and
Who is the
raw materials
petitioner?
lying there.
Who is the petitioner? He
Petitioner is the promoter.
promoter.
My lord.
And you are?
The petitioner is the promoter.
And the respondent was 6 and 7?
They are intending purchaser.
My lord, here.
So they are trying to take the raw materials.
They are in fact taking, not trying. They are taking because they have not got possession. They are trying to enforce the agreement of 2013, which I am preventing them. So instead of going to civil court,
The only thing is that if the question is of enforcement of an agreement, as my lord has rightly
Use
pointed-
microphone.
Lord has rightly pointed out, if it's a question of enforcement of an agreement, other remedies lie. However, my lord, the agreement itself stipulates that as and when construction is completed to a certain degree, payments will be made in installments. My instruction is that I have already paid them 2.5 lakhs, 1.5 lakhs and one, ekটু দাঁড়ান, 2.5 lakhs, 1.5 lakhs, 1.5 lakhs. I have paid them around 6 lakh rupees
For
already
purchasing a flat.
for purchasing
a
a
shop.
go down. A
Go down,
a
yes.
go down. Now his allegation is that I have trying to steal materials. My instruction is that they are yet to complete the construction of that go down. Hence, the last installment is due and payable as per the agreement.
Stop.
See,
It is
if they
also
have any-
it is also submitted that dispute cropped up due to violation of terms and violation of terms and conditions of an agreement made between the petitioner and respondent numbers 6 and 7 for purchasing a go down which was to be constructed by the petitioner being the developer. Stop. Next paragraph, Mr. Learned advocate representing respondent number 6 and 7 has made submissions disputing the contention of the petitioner. Stop. It is also submitted that in terms of the agreement made between the petitioner and respondent number 6 and 7, certain payments were made by the petitioner, but certain payments were made by the respondent number 6 and 7 in favor of the petitioner, but petitioner could not complete construction of godown.
And he has acknowledged the receipt by signing.
Stop. Next paragraph. State respondent Mr. Das, learned additional government pleader representing the state respondents, has filed a communication dated 2nd July 2026 of officer in charge Maniktola Police Station, Kolkata, and same is taken on record. Copies of the communication dated 2nd July 2026 are made available, are made over to the learned advocates representing the petitioner and respondent number 6 and 7. Next paragraph. It is disclosed in the communication dated 2nd July 2026 that previously petitioner, previously based on complaint of the petitioner, criminal prosecution being Maniktola PS case number 278 of 2015 was initiated, and thereafter on completion of investigation it was reported as mistake of fact. Stop. There was further investigation by the concerned police authorities, but it did not yield a result since it was also reported mistake of fact. Stop. Mistake of fact na quote unquote er moddhe dekho. Stop. Communication, aforesaid communication on behalf of the police authorities or filed on behalf of the police authorities also discloses long-standing dispute between the petitioner and private respondents. Stop. If next paragraph, if petitioner is aggrieved by failure on the part of the respondent number 6 and 7 to comply with the terms and conditions of the agreement made between the petitioner and respondent numbers 6 and 7 for purchasing a go down by those respondent number 6 and 7. In that event, petitioner needs to approach civil court due to violation of terms and conditions of contract. Stop. Next paragraph with the aforesaid next paragraph. In the present writ petition, it appears grievance is ventilated on behalf of the petitioner that complaint lodged by the petitioner was not taken into consideration by initiating a criminal prosecution. Now, stop. If petitioner is agreed by inaction on the part of the police authorities that no FIR is drawn up based on the complaint lodged by the petitioner. In that event, there is an alternative remedy available to the petitioner by approaching the jurisdictional magistrate under section 175(3) of PNSS 2023. Stop. Hence, writ petition is not entertained, same stands dismissed. However, this order shall not preclude the petitioners to approach the appropriate forum in pursuit of remedy.
I am grateful.
না দরকার নেই, এটা অন্য কনটেক্সটে করলাম তো।
এটা পরেরটা 36 যেটা কল নেক্সট item number 36. Lordship, item number 36, perhaps don't want to waste judicial time, that's why I'm making this submission. I have a report of 20th of March 2026. Lordship will find that another charge sheet was submitted, Narazi petition was filed, further investigation was again ordered. Further investigation has been continuing. The prayer is for recovery of Stridhan articles and completion of investigation in a timely manner. Now, Stridhan article, I've taken verbal instruction, it's not written form. No jewelry could be found, but however, bed and other articles, those have been seized. So, if that and handed over, I don't know, that's not my instruction, but
So it can be handed over.
if they make an application under 451 read with 450,
106 says that this seizure, if it is seized, this can be handed over.
it can be handed over subject to an
That
order of
Trinamool
the
Congress matter, this provision was being considered. Come to pay 106. Just a minute.
it is akin to 451 of the
102 previous.
Acha, 102 previous 100.
Come to 106. At that point of time, that struck my mind when I was considering Mr. Dotto was placing this provision. Come to page 100, section 106. Any police officer who sees any property which may be alleged or suspected to have been stolen to which place suspicion in the commission of such police shall forthwith seize subsection 3 is relevant. You go through 1, 2 and then come to subsection 3.
Lordship.
Just a minute.
In that event,
Or where continued retention of the property in police custody may not be considered necessary for the purpose of investigation.
in view of this, then,
Investigation,
Lordship, I will
he may
declare-
keep custody thereof to any person on his executing,
Executing
that
a-
is Zimanama bond.
Jimanama bond.
That executing a bond undertaking to produce the property before the court as and when required, or to give effect to the further orders of the court as to the disposal of the same.
Exactly what is written. in the Jimanama
Proviso
bond.
is not relevant.
Not relevant. So if
So
then
therefore,
I have to take instruction then whether it is required for retention or not.
that is the provision.
That is the provision. Without the officer telling me whether it is required for his investigation or not, I cannot then,
Because
in this matter, then
Frequently, I need to deal with this
yes,
prayer. So at the time of considering section 106, it struck my mind that
Yes.
this is
now
the
this power has
provision
been given to the police.
106(3).
Or else earlier provision was 451 read with
No, but
457
just
making
now you have
application.
submitted that this can be handed over to the petitioner.
No, Lordship. It's
Whatever is recovered or seized during investigation, this can be handed. If it
this
is not
can be
necessary,
handed over, but Lordship, I don't, that has been
you
verbally.
can take a bond from the petitioner that whenever it will be required, it is to be produced before the investigating agency or before the
That
magistrate.
is what is written in a Jimanama bond. Exactly that wording is written in a Jimanama bond. Lordship, but however, since I'm not armed with a written communication from the police, Lordship, I don't want this to flow as a verbal instruction.
He will come back after a week.
Some utensils were recovered. Thereafter, the charge sheet was filed. Thereafter, I filed Naraji petition, and the further investigation was directed. Thereafter, I approached before.
Yes, because there is no quarrel. So far, the submission made on behalf of the state. It is submitted that during further investigation, certain Stridon articles were recovered.
No, that is not the submission. That is
বলুন
not
বলুন
the-
আপনি আপনার সাবমিশনটা বলুন।
Yes, yes.
Further investigation, during the contest of further investigation, nothing was recovered. That was recovered before.
Even if that was required in the first round of investigation.
First round,
Now, then even then it has to be, it can be handed over to the petitioner in terms of section 106 within bracket 3.
The Department of the Police Authorities asked me to produce the cash memos of the ornaments, and I have
Ornaments?
Yes, madam, jewelry ornaments. And I have submitted. I have annexed the bill.
No, the provision says if you go through 106(3), then you will find that if police authorities or investigating agency finds that retention of these articles is no longer necessary for the purpose of investigation.
Lordship, subject to correction, what my learned senior friend is
There
trying
has
to
to be
submit.
And the household article, I am not interested.
To take.
I am not interested.
So then what is your submission?
This is the recovery of my
Jewelry.
jewelry.
Yes. So that to that extent, he is praying for time to obtain instruction, whether it is necessary to retain those articles for the sake of investigation or not.
And whether what my learned senior friend is trying to submit today is that he's praying that those jewelry also be seized. From what I could understand, let me
It
take.
has not been seized.
No,
Till date, it has not been seized.
I have submitted the list with cash memos.
On that respect also, I will take instructions whether what steps they have taken with respect to recovery of those and whether those are Stridon articles or just memo of some jewelry which were not part of the Stridon articles.
Oh, it's a prayer for recovery of Stridon articles.
Stridon articles.
So take instruction.
I will come back.
Issue. The matter is heard in presence of the learned advocates representing the petitioner and state respondents. Stop.
And for the
Prayer,
private respondents.
it is and private respondent number
6 to 8.
6 to 8 to ঢুকিয়ে দেবে। 6 to 8. Stop. A prayer is made in this writ petition for recovery of Stridon articles. Stop. Next paragraph, Mr. Das, learned additional government leader, representing respondents, has prayed for accommodation to obtain instruction whether Stridon articles are recovered or not.
Stridon articles have been recovered, whether ornaments have been recovered or not.
Mr. Das, learned additional government leader, submits that certain articles are recovered, but ornaments are not recovered. Stop. Prayer is made on behalf of the state respondents to take further instructions. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on July 2026.
Grateful. Item number 37.
Item number 37, Lordship, I beg to appear on behalf of the petitioner, my lord.
I am appearing for the Union of India.
My lord, in earlier Calcutta, my lord, there is a direction upon the state respondent to.
Yes, where is
report, my lord.
the report?
তুলে দিয়েছে তো।
বুঝেছো?
আমাকে একটা কপি দাও।
So your Facebook account is still locked.
No, my lord, I have no instruction, but Mr. Das is saying that he's already been opened, my lord. Mr. Das is saying.
No, it has been followed up with the platform for early restoration of the account.
Whether Facebook account is unlocked.
Your Lordship, Miss Amirana, she's on her legs in another court. So if this could be taken up tomorrow, we would be very grateful.
Just a minute, let me go through this.
Yes, lord. Lordship, may consider the আমার একটা copy দেবেন?
Tell your senior to come. You will get some time. Let me go through the report which is being filed on behalf of the state respondents.
Yes, Your Lordship.
Paragraph 6 देखो ना
Facebook
Facebook
now it's up to Meta. Meta have to open it. The request has already sent. It has to.
ChatGPT tools.
Okay.
Your Lordship,
Just a minute.
Now I'm not in ChatGPT.
Yes, as per the communication made by concerned investigating agency to ADG and IGP, Cybercrime Wing West Bengal, it was required to block certain posts which were available on Facebook, not the Facebook account of the petitioner. Not the whole Facebook account of the petitioner.
Your Lordship, according to the notice that
Therefore, there is a need to unblock the Facebook account of the petitioner immediately. 5 and 6. Yes, what is your contention?
Your Lordship, if instructions are given to us to restore the account, we shall do the needful.
Yes, yes.
If instructions are given to us to restore the account, we shall do the needful.
Issue. Pursuant to the previous order passed by this court. A memo dated 22nd June 2026 of ADG and IGP Cybercrime Wing, West Bengal, enclosing memo dated 22nd June 2026 of Deputy Superintendent of Police, SM Cell, Cybercrime Wing, West Bengal, is placed before this court and same is taken on record. Stop.
Your Lordship,
Next paragraph. Yes, yes.
Your Lordship, I'm so sorry for interjecting. If my senior could just appear and assist you tomorrow, we would be very grateful.
It's not required because investigating agency has already submitted a report in favor of the petition.
Okay. Much obliged, Your Lordship.
It is next paragraph. On perusal of memo dated 22nd June 2026 or on perusal of memo number 673/SM cell /WBCCW/2026 dated 22nd June 2026 of Deputy Superintendent of Police, SM Cell, Cybercrime Wing, West Bengal. It is found at the time of taking steps on making GD entry number 191 dated 191 dated 12 March 2026. Concerned police station inadvertently sent URL of the Facebook profile of the petitioner instead of URL of the specific objectionable post. Stop. Consequently, entire Facebook profile of the petitioner was blocked by respondent number 9. By respondent number 9, instead of restricting access only to those objectionable content. Stop. Next paragraph, taking note of inadvertence as disclosed in the aforesaid memo dated 22nd June 2026, barring objectionable content.
Lordship, there are no objectionable contents. There are no objectionable contents. It was an expression of freedom of speech. That is the reason the entire account, including that particular URL, can be
Stop. তাহলে এখানটা কেটে দাও। Taking note of থেকে কেটে দাও। It needs to be recorded. It needs to be recorded herein that Mr. Das, learned additional government pleader representing the state respondent, submits that as such there was no objectionable post. So on the Facebook post found on the Facebook account of the petitioner. Stop. Next paragraph. Taking note of the contents of the memo dated 22nd June 2026 and the submission made on behalf of the state respondents, respondent number 9 is directed to restore Facebook account of the petitioner by 48 hours from date. Stop. Next paragraph. Writ petition stands disposed of. You restored the account by 48 hours because I have recorded the submission of the learned additional government pleader that there was no objectionable content on the Facebook account of the petitioner.
Much obliged, Your Lordship. If we could be given a week to restore the account, we would be very grateful.
Why weeks? Take 3 days.
3 days.
48 hours or 72 hours.
Much obliged, Your Lordship.
Careful to your lordship. অনেক দিন ধরে চলছে শেষ করে।
Item number 38.
Private. Instruction. Yes, who is for the petitioner?
I'm for the petitioner. The question cropped up in this matter is whether inquiry can be done in a case of SCST Act or not. Preliminary inquiry can be done or not. Kindly have a look into the.
What was the case made out? That who has taken up the case for investigation?
The second question was the DSP. The less than DSP, they cannot be investigated.
Yes, that is provided in the act itself.
Yes.
But apart from this, you may have submitted that the officer below the rank of DSP has initiated the investigation.
DSP cannot investigate or inquiry.
Who is investigating at present?
The inquiry started by a sub-inspector, which is not permissible by the law. Now, even the inquiry is not permissible in this case. Kindly can have a
preliminary inquiry is not permissible.
Not permissible. Kindly
May I
see
just submit? I am not
18A.
joining issues with my senior friend on the aspect of point of law. I had spoken to the DSP of the concerned police district. They were ill-advised by a certain person. I have told them
Now, whether it has the defect is corrected.
No, it has not yet been rectified. They are taking steps to rectify it. It is true that a officer below the rank of a DSP was assigned.
Is not authorized to carry on investigation.
There is no.
There are two aspects, Mr. Das. First aspect is this: according to the petitioner, there is no scope of
Preliminary inquiry.
conducting preliminary inquiry, and second, investigation has to be conducted by an officer of the rank of DSP
Minimum
or
DSP
above.
or above. Not below the rank of
Not
DSP.
below the rank of DSP.
And ACP in case of a commissioner. That I have clarified to them the legal provisions. The DSP has assured me that he will be taking necessary steps to rectify those errors. I believe, Lordship, a DSP ranked officer will be assigned to investigate this case. Now, preliminary inquiry has already been done. Now, we cannot go back in time to rectify it.
That cannot be withered away.
That cannot be withered away. What is there on the face of the records. So, henceforth, Lordship, if as per whatever falls from your Lordship, the police is going to comply with that.
Now, the question is whether the inquiry, it was bad in law. So, that cannot stand.
Inquiry?
It was bad in law because statute doesn't permit any preliminary inquiry. Now, kindly see 18A for once. Now, they have
conducted
No, one
inquiry.
thing, Mr. Das, if inquiry is wrongly conducted, then that inquiry cannot be written on record.
It cannot be written on record.
So DSP or the appropriate police authority, police official has to start investigation strictly in accordance with the four corners of the statute.
Yes,
Without
considering or even
laying any emphasis
on the inquiry
on the
report
inquiry.
and on the inquiry report. That is what I've suggested to them, Lordship. I have this report.
That inquiry report cannot be taken into consideration.
Definitely, Lordship.
And that inquiry report cannot written on record.
Yes. From the report, Lordship, what I've placed before your Lordship, he has dealt with the allegations and the falsity or veracity of the allegations as such. I am not getting into that. That is part of the investigation. Whatever will follow from the investigation will follow. With respect to the provisions of law, Lordship, if my Lord kindly grants me some more time, my Lord had earlier directed to furnish a report. I've gotten a report on the factual aspects of it. Now, what steps they have taken after my discussion, that is not reflected in this report, perhaps.
Very well, let him grant. If it is
no problem.
if the concerned investigating agency is
To err is human,
has
Lordship.
decided
Yes.
to rectify the previous mistakes,
My lord.
then the chance be given
Yes,
to
my
them
lord. My lord,
to
the-
take steps in accordance with the
Yes, yes, my lord.
provisions
The
of the statute.
only question I'm saying is that since my learned friend is saying investigation can be done only after registering a FIR. If they register a FIR, then my lord, my first prayer is infructuous because my first prayer, my lord, they have not started investigation. And then my lord, my second prayer is that the inquiry is bad in law, which cannot sustain. So my lord, if
And
FIR
this
is
state
registered,
court need not be very descriptive in passing order. Let the matter be adjourned,
my lord.
permitting the concerned police officials to take steps in accordance with the relevant provisions of this Act of 1980.
My lord. Release.
Don't elaborate; it may go against you.
So
There
there
are
are
difficulties.
factually there are incongruences in the complaint also, but it has to be done after registration of the
Let
FIR.
them
The
come
FIR may
with
FIR
a
may continue into
rectified
FRF.
My lord,
But,
my lord.
or with an altered approach before this court. And if the previous mistakes are rectified, then your grievance may be
Yes, my
redressed.
lord. My
As
grievance will be addressed.
today, why my learned senior friend is joining issues with me is because in the inquiry report, the facts which have been stated, these harsh provisions of this particular harsh act has been invoked. There are falsities in the claims. I don't want to get into it, but if a FIR has to be
Lord,
registered, if a FIR will be registered,
The investigation will be carried on.
whatever the
my
phase
lord,
of the investigation
my
it
lord,
is.
may I say one thing to answer this? My lord, even before starting a FIR, if state is saying the entire allegation was
Focusing on
false,
the inquiry report.
well then,
Only
my lord,
the inquiry report cannot be considered. Let us assume that the inquiry
well,
report is
that
not
was
there.
done by a different
No, he is
IO.
submitting that the steps were taken which were not permitted under the statute.
Yes.
So that is your
Yes, my
first
Facts cannot be denied.
yes.
Lord,
Something is
That is your
fact is a fact.
main objection so far the present petition is concerned. So let them come back with a rectified stand,
yes,
which
yes,
would be
yes,
in
yes.
consonance
But
with
since
the
my learned
relevant
friend is
provisions of
saying
1989
that fact is
1989
fact,
90
meaning thereby even if it is, my lord, investigated by the DSP, the
today
same
on
outcome
behalf
will
of
come.
the state,
No,
But you
that is
cannot say that
absolutely not my
at this
submission.
stage.
today on
I am
behalf
only
of the
basing my
state
submissions on the
respondents,
inquiry report
a
and
communication
the report
dated
before me.
That is the opinion of a sub-inspector. That's not the opinion of
8
the
February,
DSP.
a communication dated 2nd July 2026 of sub-inspector of officer in charge, Ganganagar Police Station, Nodia, is filed and same is taken on record. Stop. Learned advocates representing the petitioner and state respondents have made submissions from where stop. From the submissions made on behalf of state respondents, it appears that concerned investigating agency or concerned police authority has or concerned police authority will be required to take steps for initiating investigation, taking note of the complaint lodged by the petitioner in terms of the relevant provisions of the scheduled castes and the scheduled tribes within bracket Prevention of Atrocities close bracket Act 1989. Next paragraph. Considering the stand taken on behalf of the state respondents, court finds opportunity should be granted to the concerned opportunity should be granted to the police authorities to take steps accordingly. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 30th July 2026. July. Next.
দাদা বইটা দাদা
Item number 39.
I am for the petitioner, my lord.
I'm for the private respondent.
Last occasion, your lordship directed to submit a report, my lord, because my lord, the petitioner is a senior citizen, mother, my lord, of the
Yes, what is the matter about?
matter is that, my lord, the petitioner is the mother of the respondent number 7, my lord, and my lord, the mother-in-law of respondent 8, my lord. My lord,
7 and 8.
yes, my lord.
Son and daughter-in-law.
Daughter-in-law, my lord.
Yes.
With good faith, my lord, they assure, my lord, to maintain her mother, my lord. He gave and my lord, the forcefully, my lord, the retain, my lord, all the properties, my lord. Thereafter, my lord, they
she did the mistake.
Yes, my lord.
Now she did the mistake. She committed mistake.
He's
Petitioner
asking,
being the
he will
mother
maintain
committed
my
mistake.
mother, my lord.
Why she has given all her
They have
property to the son?
they assume, my lord, they will maintain my mother, my lord.
Now
But
what is your yes it was given.
they
Now
have not look after mother and driven from the house of the petition.
so then you approach the jurisdictional authority under 2007 Act
That
for
is true, my lord, but
compensation and maintenance. For
I have not
compensation and
entered into my
maintenance, you
house also,
approach
my
the
lord.
appropriate authority
My
under the 2007 Act.
son and daughter-in-law, my house, my lord, I'm not permitted to enter into my house, my lord.
So if you have given this house or gifted this property to your son, now today police authority cannot take you to that premises where you are not being permitted to stay.
They have some liability to my lord to maintain my mother.
Yes. What is your instruction?
Yes, some steps has been taken. His mother is residing now at that
At the
point,
premises.
at that premises, and one NCR case has been registered, and his son has been cautioned that don't do this with his mother.
You don't have any instruction.
Thereafter,
You don't have instruction.
Yes.
So you are making same submission based on the case made out in the petition.
Thereafter, my mother is not come with my chamber.
Lordship, already they approached before civil court, your lordship, for cancellation of that deed also.
Now the petitioner, your mother is staying with you at the same residence.
With me and with the other sons also.
Yes.
There are eight children of this petitioner, your lordship. They stay at as her will wish.
I am asking you whether the
my restrictions.
mother of petitioner is staying at the residence of the son who is party in this writ petition, or she is staying elsewhere. He may have eight children or eight sons, but since the property is gifted to respondent number 7 by mother, then is it not your duty to look after your mother?
Lordship, the mother is in my house, your lordship, and I provide day-to-day care, your lordship.
May I hand over report copy?
Yes, give. Petitioner, being mother of respondent number 7 and mother-in-law of respondent number 8, has approached this court with the present writ petition, seeking a direction upon the concerned police authorities which would enable the petitioner to stay at the residence which was gifted by her to respondent number 8, and she will be looked after by the respondent number 8 and by respondent number 7 and 8. Respondent number 8 হবে না, এটা respondent 7 হবে, দেখো gifted 7, and she will be looked after by respondent number 7 and 8 by providing necessary assistance. Next paragraph. A communication dated 20 June 2026 of officer in charge Raninagar Police Station, Murshidabad Police District is placed before this court and same is taken on record. Copies of communication dated 28 June 2026 are made over to the learned advocates representing the petitioner and respondent numbers 7 and 8. Stop. It is submitted on behalf of the state respondents that on intervention of the police of the concerned police authority, respondent number 7 agreed to provide daily needs to his mother, being the petitioner herein, which would enable the petitioner to lead normal life, which would enable the petitioner to lead decent and normal life. Stop. Next paragraph. Learned advocate representing respondent numbers 7 and 8 has also assured before this court that petitioner would not find difficulty in staying at the residence which was gifted by the petitioner in favor of respondent number 7. Daily necessities shall be provided to the petitioner for leading shall be provided to the petitioner for leading decent life. Next paragraph. Concerned police authorities are directed to keep vigil and to ensure that petitioner is looked after by respondent number 7 and 8. Next paragraph. Writ petition stands disposed of urgently. Take care of your mother.
Lordship, already a partition title should have been filed, your Lordship.
Item number 40.
Private respondent number 6, 7, and 8.
On behalf of the petitioner.
Yes.
I'm on behalf of the petitioner.
For the private opposite parties.
My affidavit of service.
Have you served notice upon respondent number 5?
Yes.
When respondent number 5 received it?
Served upon them on 18th of this month.
18th of this month. Yes, what is the matter about?
The private respondents happens to be my relatives, my lord. There is a problem with regard to a property. There is a property dispute, my lord. They encroached upon my property, my lord. Lord, during the pendency of this writ petition, my lord, we have preferred an application under section 175(3). The concerned
Jurisdictional magistrate.
jurisdictional magistrate, my lord, had asked the concerned police station to register an FIR, my lord. But they're yet to register an FIR, but the matter stand resolved, my lord. Lord, I intend to not press this application.
Not pressed. Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Learned advocate representing the petitioner submits on instruction that writ petition is not pressed. Next paragraph. You are representing respondent
I'm
number?
representing private respondent number 6, 7, and 8.
State respondents and respondent numbers 6, 7, and 8 are represented by learned advocates. Next paragraph. In view of submission made on behalf of the petitioner, writ petition stands dismissed as not pressed. Parties to act on the server.
Deeply. Item number 41.
Lordship, I appear for the petitioner in this.
Yes, 41.
I appear for the petitioner. Lordship, this is, in this matter, I am the owner of a land measuring about 60 shortok, actually belonging to my husband, which my husband has gifted in favor of my daughter, a physically disabled daughter. And after the death of my daughter, I am finding that all of a sudden, I was continuing cultivation in this land. It's a Shali land. I was continuing the cultivation because my daughter was physically disabled. I have gifted the land, but I was continuing cultivation. So all of a sudden, I find that the private respondent number 6, Hare Krishna Ghosh, claims the land and is trying to obstruct my cultivation activities over there, which I'm continuing. Accordingly, I have filed a title suit before the learned civil judge, Junior Division, Chichura, and over there, wide order dated 18th of March, 2025. Lordship will find it at page 17.
Yes, yes.
That I obtained an ad interim order of injunction from there. Accordingly, the officer in charge, the respondent number 5,
has failed, in spite of repeated requests, have failed to take any steps against the private respondents. Accordingly, through my son, I have also filed.
Now, there is an order of ad interim order of injunction was passed. Yes.
After that, also I have filed 163 BNS. Okay. But over there, in order to seek certain assistance,
What you are praying for in this writ petition?
I pray. I have filed all the police authorities are refusing to comply with the orders.
Which order?
I have also filed section 151.
Which order, implementation of which order you are praying for?
Lordship will come to the prayer portion. 3rd February 2026.
You are praying for implementation of the injunction order passed by the civil court. You file an application under order 39 rule 2A, read with 151 CPC.
Lordship, I have.
This court is not the appropriate forum for implementation of the ad interim order of injunction passed by the civil court.
Lordship, in spite of I already so much time has already gone, and I have.
Is it the forum for implementation of the order of the civil court?
I have already also underwent an 151 application, Lordship.
There is a provision under order 39 rule 2A.
Despite that order, it has already the police has already been directed to take steps against the private respondents.
And Lordship, I have the instruction that police has promptly taken action in that.
You keep your instruction with you. It's not required. Just a minute. Consequence of disobedience or breach of injunction. Order 39 rule 2 capital A. Approach the civil court. Or and read with 151 CPC. If writ court is writ court start issuing mandamus for implementation of the order of the civil court, then
I've already filed an application
where
under
the functions
151,
of the
Lordship.
CPC will go. Issue. Affidavit service you have filed previously. Matter is heard in presence of the learned advocates representing the petitioner, state respondents, and respondent number 6. Stop. From the submission made on behalf of the petitioner, it appears concerning an agricultural land. Dispute cropped up in dispute subsists in between the petitioner and respondent number 6, which prompted the petitioner to approach civil court by filing title suit number 149 of 2025. You are the plaintiff therein. Stop. An ex parte ad interim order of injunction was passed on 18 March 2025 for a limited period, thereby directing you are the defendant number 1 there.
Yes.
Thereby directing the respondent number 6. Respondent number 6 being defendant therein.
May I submit one thing only, Malad? This ad interim order was subsequently heard in presence of both the plaintiff and defendant, and both the party by a subsequent order, both the parties of the suit were directed to maintain status quo with regard to the nature, character, and possession of the suit, Malad. Since I have purchased this property through a registered deed, Malad, and from the date of the registration of the property, I am in occupation of that property. It is an agricultural land, Malad. I am in.
Thereby directing. Now, thereby restraining respondent number 6 being defendant therein. Respondent number 6 being defendant therein from dispossessing plaintiff from the suit property and from changing nature and character of the suit property. Stop. Petitioner prays for implementation of the aforesaid ad interim order of injunction dated 18th March 2025 in this writ petition by giving direction upon the concerned police authorities to take steps, thereby ensuring right of the petitioner over the land in question. Next paragraph. Learned advocate representing respondent number 6 has disputed the submission made on behalf of the petitioner, and it is said that petitioner has purchased the land in question.
And my name is also appearing in the.
Please hear the order. It is also submitted that order dated ad interim order of injunction dated 18 March 2025 stood modified subsequently by the civil court after hearing the learned advocates representing plaintiff and defendant. Stop. Next paragraph. In the present writ petition, prayer is made for implementation of the order dated 18 prayer is made for implementation of the of ad interim ex parte ad interim order of injunction dated 18 March 2025, which was passed for a specified period. Stop. This court is not the appropriate for this court while exercising jurisdiction under Article 226 of the Constitution of India is not an appropriate forum for implementation of the ad interim or ex parte ad interim order of injunction passed by civil court passed by civil court in a suit instituted by the petition. Stop. Moreover, it is submitted on behalf of respondent number 6 that subsequently ad interim order of injunction dated 18 March 2025 stood modified. Next paragraph. Hence, no relief can be granted to the petitioner. Stop. Writ petition stands dismissed. However, this order shall not preclude the petitioner to approach civil court in pursuit of remedy. Urgent xerox certificate.
Obliged, Lordship.
Instituted by the plaintiff. Petitioner plaintiff.
Item number 42.
At the time of call, no one appears for the petitioner and no accommodation is prayed for. Stop. Stop. Same situation prevailed on 20 May 2026. Stop. Next paragraph. It appears petitioner has lost interest. Stop. Writ petition stands dismissed for default. Parties to act on the server copy. Next.
Item number 43.
Lord, this matter, Lord, I'm appearing for the private respondent number, Lord, 789. Lord, this petition is not maintainable, Lord. Because of this reason, on the one hand, he has challenged the order dated 20th January 26 passed by the land CGM, Howrah. And on the other hand, he has.
So you will start making submission, though it is not your petition.
No, I'm sorry. No, that's a maintainability point I've taken. That's why.
ধর্মাবতার আমি প্রতাপ বসু বাংলায় বলতে চাই, পিটিশনার ইন পার্সন। গত 4/12/2022 তারিখে শুভ্রদীপ ভাদুড়ি, লিটন ভাদুড়ি যার ওরফে নাম, তো ওনার বাড়িতে আমি ভাড়া যাই। তো আমি সরকারি জমি বাঁচানোর জন্য আমি প্রায় 12 বছর বাড়ি ছাড়া ছিলাম। আমার জন্য আজকে দক্ষিণ পূর্ব রেলওয়ে প্রায় 275 একর জমি ফেরত পেয়েছে দুটো মৌজায়, উনসানি মৌজা এবং দুইলা মৌজায়। তো তো আমার বাড়ি থেকে ঠিক রেল লাইনের অপোজিটে, আমার বাড়ি মৌরিগ্রাম স্টেশন পাশে, তো তার অপোজিটে ঠিক 300 মিটারের দূরে আমি ভাড়া থাকি, এবং কোনোদিনের জন্য আমাকে কোনো রকম রসিদ দেওয়া হয় না, কোনো কিছু দেওয়া হয় না। তো কিছুদিন পর উনি আমাকে ভাড়া উঠে যেতে বলেন। তো আমি বললাম যে আমার বাড়ি করছি, আমাকে একটু সুযোগ দিন, তারপরে আমি নিশ্চয়ই উঠে যাব, আপনার বাড়িতে তো আমি চিরকাল থাকতে আসিনি। তো এই করে বারবার আমাকে মানসিক টর্চার করেন, এবং আমার কাছে বহু ভিডিও রয়েছে, রাত্রিবেলা 11:30 12টা মত্ত অবস্থায় এসে আমাকে যা ইচ্ছা তাই বলেন। ওনার দাদা আমার থেকে ভাড়া নিচ্ছেন, মুখ লুকিয়ে এইভাবে ভাড়া নিচ্ছেন আমার থেকে। এবং ধর্মাবতার, আজকে বলে দিই আপনাকে, প্রায় 4 বছর অতিক্রান্ত আমাকে চিফ জাস্টিস মহাশয় এই সরকারি জমি বাঁচানোকে কেন্দ্র করে বারবার আমার উপর আক্রমণ হয়েছে, যার ফলে আমাকে সিকিউরিটি পর্যন্ত দেওয়া রয়েছে। সিকিউরিটির সামনে পর্যন্ত এমন অশ্রাব্য ভাষায় গালাগালি করছেন, যেগুলো কানে দেওয়ার নয়, সমস্ত কিছু আমার কাছে রয়েছে। তো কিছুতেই, এবং আমি এই বিষয়টাকে কেন্দ্র করে হঠাৎ করে আমি 2025-এর ফেব্রুয়ারি মাসে আমি ইয়েতে যাই, আপনার কুম্ভ মেলাতে যাই। আমি যখন ফিরে আসি তখন দেখি আমার ঘরেতে তালা, প্রথমে কারেন্টের তার কেটে দেওয়া হয়েছে।
একটা ক্রিমিনাল প্রসিকিউশন ইনিশিয়েটেড হয়েছিল, তার রেসপেক্টে একটা রিপোর্ট ফাইল হয়েছে, এফআরটি ফাইল হয়েছে।
হ্যাঁ, ধর্মাবতার,
আপনি সেই এফআরটিটা চ্যালেঞ্জ করে এখানে এসেছেন।
চ্যালেঞ্জ করে এসেছি। হ্যাঁ,
এখানে তো হবে না চ্যালেঞ্জ, আপনাকে জুরিসডিকশনাল ম্যাজিস্ট্রেটের কাছে 193(9) গিয়ে চ্যালেঞ্জ করতে হবে।
তাছাড়াও আমার ঘরের যে মালপত্র রয়েছে, আটকানো রয়েছে আমার ঘরের মালপত্র, সেই নিয়েও আমি আপনার কাছে
এফআরটি যেটা ফাইল হয়েছে
ধর্মাবতার,
ইন কানেকশন উইথ দ্য ক্রিমিনাল প্রসিকিউশন, তার বিরুদ্ধে আপনি নারাজি পিটিশন ফাইল করতে পারেন।
নারাজি আমি পিটিশন ফাইল করছি
বিফোর দ্য জুরিসডিকশনাল ম্যাজিস্ট্রেট আন্ডার সেকশন 193(9) অফ বিএনএসএস। রিট কোর্ট ইজ নট দ্য অ্যাপ্রোপ্রিয়েট, এই কোর্ট অ্যাপ্রোপ্রিয়েট ফোরাম নয় আপনার এফআরটি চ্যালেঞ্জ করার।
ধর্মাবতার, আমার যে ঘরে মালপত্রগুলো আটকানো রয়েছে আমি বের করতে পারছি না।
Naraji petition's file has been rejected.
My lord, on behalf of the restaurant number 5, in charge of Jagacha police station, may I have to find the instruction of police station?
ধর্মাবতার, আমি তাহলে কি করব? আমার এই মালপত্রগুলো ফেরতের ক্ষেত্রে কি করব? আমি ঘরে ঢুকতে পারছি না, ঘরে ঢুকতে পারছি না, এবং মালপত্র আটকানো রয়েছে। আমার সমস্ত পয়সা কড়ি সব মিটিয়ে দেওয়া রয়েছে, বাড়ি ভাড়া।
Go to civil court, there's a civil dismissal.
কতদিন ধরে আটকে রেখে দেওয়া হবে? থানার আইও কখনো আমাদেরকে বসায়নি এক জায়গায় কি বিষয়টা জানবার জন্য। কখনো থানার বড়বাবু সবসময় নেগলিজেন্সি ভাব, এনারা অনেক প্রভাবশালী। ধর্মাবতার, আমার ঘরে মালপত্র আটকানো রয়েছে, মালপত্রগুলো যাতে বের করতে পারি ধর্মাবতার।
No, but there is no indication in the communication dated 24 June 2026 that there was an subsequent inquiry after filing of Naraji petition. Where is stated? You have submitted that Naraji petition was dismissed.
They have complete law before Jagacha. Call for
Is Naraji petition was filed.
Naraji petition was filed, that has been rejected. And the petitioner filed for discharge of the petitioners. That was filed a discharge of the petitioner in this case, and that was allowed. And not only that, the Jagacha PS, the IO made an investigation.
Naraji petition was disallowed.
Disallowed, rejected. And Lord, the made an inquiry, made an investigations, IO, and he suggested for discharge of this petitioner on the basis.
Allow the petitioner to take his belongings, which are lying at your residence.
Lord,
My lord, I'm just interrupting. There is
No,
I'm
no, this is not a
final
club that
response.
everybody will jump upon. Yes, allow the petitioner to take his
I'm
belongings.
telling your lordship.
Otherwise, I will direct the police authority to do the
No, Lord, I'm telling you further facts. This the role of the petitioner. Lord,
It appears from the report of the police that there is an area rent due from the petitioner, which is payable by the petitioner, which petitioner could not pay, for which his belongings are not released. That is not the way you approach the civil court for realization of rent, but his belongings cannot be kept within the premises of the landlord.
yes, Lord.
So when it will be handed over to the petitioner?
My lord is perfectly right.
He has already been evicted. When his belongings will be handed over to the petitioner?
Lord, I'm telling
Take human approach.
No, Lord,
Otherwise,
I'm-
you will face the music.
I'm assured that your lordship, that's what your lordship is telling. My lordship is appreciable. But Lord,
Very well, it is accepted.
Lord,
His
I'm telling you, Lord,
Naraji petition was disallowed. There was no further inquiry, and petitioner is evicted from the premises due to non-payment of rent. All are accepted. But if belongings are lying there, I will direct the concerned police authority to enter your premises and take the belongings, and it will be handed over to the
no,
petitioner.
Lord, they would sit together.
So
they
when
would
you
dis-
will hand over the belongings?
ধর্মাবতার আমার এই গাড়িগুলো পারমিট শেষ হয়ে
Wait,
blood, I'm telling you, lordship, this character is, he is claiming himself as a social activist.
I am not concerned with these things. Whether any of the articles of the petitioners are lying there, or yes or no. Whether he is a social worker or political worker, or in other person,
Yes, Lord,
whether
if-
he has
if,
other
Lord,
work to
if
do,
there is-
I am not concerned.
Lord, if there is any belongings, if they are in belongings, he has to return this.
When it will be returned?
আমার ঘরে তালা মেরে দেওয়া হয়েছে
Lord,
ওকে ঢুকতে দেওয়া হয় না
That I have seen from the report.
কারেন্ট কেটে দেওয়া হয়েছে
They will sit and they will return back within 7 days of it.
Hand over the belongings to the petitioner. I will direct the police authorities to take steps accordingly, so that the belongings of the petitioners can be handed over to the petitioner by 7 days and file a further report issue.
And not in that event, he has to give the list of belongings. What belongings? If it says my belongings.
That police authority will record. It will be in front of the police authority.
ধর্মাবতার আমার আর একটা ছোট্ট কথা অনুরোধ রয়েছে
আর কোনো অনুরোধ নেই।
ধর্মাবতার চাবিটা আমি এখন বলবো চাবিটা যাতে
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner appears in person and submits.
অন্যায়টাকে কি করে আপনারা সাপোর্ট করেন সোশ্যাল অ্যাক্টিভিস্ট
There is a dispute between tenant and landlord.
Jail custody. It is your business.
Which gave rise to a criminal prosecution being Jogacha PS case number 63/25 dated 27 March 2025 under certain provisions of BNS. Stop. However, take it down. Next paragraph. Learned advocate representing the state respondents has filed a communication dated 24 June 2026 of officer in charge Jogacha Police Station, Howrah Police Commissionerate, and same is taken on record. Next paragraph from the said copies of the communication dated 24 June 2026 are made over to the learned advocates representing the petitioner and respondent number 6. Next paragraph. From the report, from the communication dated 24 June 2026, it appears that it appears that Jogacha Police Station case number 63/25 dated 27 March 2025 culminated into filing of final report being Jogacha PS FRF number 118. Is it FRF or FRT? FRT number 118/2025 dated 21st June 2025. Stop. Petitioner made an application under section 193 within bracket 9 of BNSS 2023 questioning final report. Stop. However, it is submitted on behalf of the state respondents and respondent number 6 that application under section 193 within bracket 9 BNSS 2023 seeking further investigation was disallowed by the jurisdictional magistrate. Next paragraph. However, it is submitted by the petitioner that his belongings are kept inside the premises where he was staying at inside the premises in question where he was staying as tenant. Next paragraph. On behalf of respondent number 6, it is submitted that by 7 days belongings which are lying at the premises shall belongings of the petitioners which are lying at the premises in question shall be handed over to the petitioner. Stop. Next paragraph. You have not made officer in charge as party. You have not made officer in charge as party.
হ্যাঁ অফিসার ইনচার্জ তো রয়েছেন ওখানে।
Which respondent? Inspector in charge.
Inspector in charge.
Inspector in charge 5.
Inspector in charge.
Inspector 5.
Jogacha Police Station being respondent number 5 is directed to cause an inquiry and file a report on the disclosing whether belongings of the petitioners are handed over to him by the respondent number 6 or not. Stop. Let such report be filed by fortnight from date. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 23rd July 2026. In the meantime, by 7 days, you take steps, hand over the belongings, and thereafter, of the inspector in charge shall cause an inquiry and submit a report. Oh, did
আমি দিয়ে দিয়েছি মনে
Item number 44.
আরে উনি তো পিটিশনার, ওনার নাম তো পিটিশনার ইন পার্সন। অন্যগুলো নিয়ে নাও। Yes, who is for the petitioner?
My lordship, I am for the petitioner. I have served the affidavit of service on the other side. It's the affidavit.
আরেকটা করে কপি করে যাচ্ছে।
একটা করে কপি আর দিয়েছে এই
My lordship, the petitioner disappeared on 21/9/2024.
প্রোটেক্টটা এই মহাপরাধটা আরো দুটো আছে প্রোটেক্টটা
6969.
Yes.
My lordship, the petitioner disappeared on 6/9/2025, and we filed
Petitioner?
6/9/2025. The petitioner's husband.
Husband?
Yes.
What happened?
He went missing. Therefore, we filed the petitioner.
When husband of the petitioner went missing?
6/9/2025, my lordship.
6/9/25.
Yes, my
Yes.
lordship. Therefore, we filed a GD 373 at Noapada Police Station. Yeah, Noapada Police Station on 6/9/2025. Therefore, therefore a critical digital footprint was found by about him on 8/9/2025. Still, the police state respondents did not take immediate action. We also filed a petition. We also filed a representation to Missing Person Squad at Albazar, Annexure P4. Annexure P4.
Yes, any report, Mr. Bhattacharya?
Still no action was
I have
taken, my
come to the
lordship.
report. Actually, initial complaint was lost to the Noapada police station. So I have a report of the police station. They have taken all necessary steps, but still now missing.
করেছি কিন্তু
Petitioner's father went missing.
Yes.
Father?
Yes.
Two petitioners.
Two petitioners, son, wife and father.
No, just now you have submitted that the husband of the petitioner. So he's a missing person is the father of petitioner number 2.
Yes, sir. Yes, my lordship. No, I টেস্টটা করতে হয়েছিল আইপি টেস্ট করতে হয়েছিল হ্যাঁ আইপি টেস্ট করার পরে
পেট নিচে আর কিছু করার নেই ভালো চলছে
5913. 5913. দেখো মিলা।
ভার্চুয়াল জয়েন করে যেতে পারি আমি। জজ দেখে নিয়েছে? আচ্ছা, ওই ব্রিফটা তোমার কাছে আছে।
পেন্টিং এর গুলো তো দাঁড়াও, দাঁড়াও, দাঁড়াও। দাঁড়াও, 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 দাঁড়াও।
দিয়ে দিয়েছি।
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Petitioners have approached this court with the present writ petition, inter alia praying for a direction upon the concerned police authorities to trace out husband of petitioner number 1 and father of petitioner number 2, namely Ashok Kumar Ghosh. Stop. Stop now. Who went missing on 6 September 2025. Yes. Next paragraph. On behalf of the state respondents, a communication dated 29 June 2026 of officer in charge Noapara Police Station, Barakpur Police Commissionerate is filed and same is taken on record. Stop. Copy of the said communication is made over to the learned advocate representing the petitioner. Next paragraph. It is disclosed in the communication that several steps have already been taken to find out Shed Ashok Kumar Ghosh. Stop. On 13 November 2025, a prayer was made before the officer in charge, missing person bureau, officer in charge, missing person bureau, CID, West Bengal, Bhavani Bhavan, Kolkata, for publication of a criminal intelligence gazette, within bracket CIG, close bracket, notice, along with 12 copies of missing persons photograph. Stop. One IP, capital P, IP address was detected, but on taking steps, it was found that said IP address has no nexus with the missing person. Next paragraph. Next, in view of this disclosure of steps taken by the concerned police authority, it ought not to be inferred that steps were not taken to trace out the missing person. Next paragraph. However, police authorities are directed to continue with the effort to trace out husband of petitioner number 1. Stop. Another report is called for. Stop. List the matter under the same heading for further consideration on 10th August 2020.
Report from which authority, my lord? Report from which authority, my lord?
Another report from the concerned police authority.
That is now CID is under
No,
investigation.
no, CID, there is a communication.
This police officer, this police officer.
Let the effort, further effort be made to find out. Grateful.
Thank you, sir.
Item number 45.
But 45 not for the petitioner, my lord. But this is the affidavit of service, my lord. Private respondent's service is not completed because insufficient address. And my lord, there is a reason for that. This is a case of land grabbing. The local hooligans, private respondent number 5 to 9 are the local hooligans who have been threatening me, trying to remove from my own property, my lord. Even after filing this writ petition, my sister-in-law have been getting threat call that my body will be cut into pieces. Multiple representation, no action on the part of the police authority. Now, my lord, record of rights, my lord, is at page number 18 to 20, which shows that the land belongs to me. The boundary wall was.
They will say that the land is owned by them.
No, my lord, they cannot produce one document because I have all the documents.
So therefore, police authority is not the appropriate authority to
My lord,
decide it.
my lord,
You approach the appropriate forum.
Grateful, my lord. Just one thing may I indicate before you, lordship, my lord. There is an incident that after the change of political power on 5th May 2026, my boundary wall was been demolished, my lord. I have been continuously threatened, my lord. There are criminal antecedents against them. Police is taking no action, my lord. Kindly considers my representation once, my lord. Just. My lord, representation is at page number 38, my lord. Kindly considers that. Previously also there are representations, my lord. They are continuously.
This is not a representation, advocate's letter.
My lord. Well, page number 21.
The legal notice.
Page number 21. This is the subsequent notice that I have made after I have been getting the threat calls and all those things. Page number 21 is also there.
Anything more?
No, this is all. 23 is my representation and 24 is the.
So no affidavit of service.
Affidavit of service is here, my lord.
No, it is not complete. No use of
Insufficient
filing.
address, my lord.
Next paragraph. Recorded order. Learned advocate representing the petitioner submits that in spite of making effort to serve notice upon respondent numbers 5 to 9, service could not be effected. Stop. However, state respondents are represented by learned advocate. Next paragraph. Learned advocate representing the petitioner.
I don't only one thing to notify that.
Now, whether the FIR is registered.
No, Lord. The prayer is for is
Registration
specifically for
approach the
prayer.
appropriate
Registration of FIR and for protection, my lord. I have medical reports, my lord.
কি বলছিলাম? Submits that. Now, কেটে দাও. Prayer is made in this writ petition for registering FIR based on the complaint lodged.
For protection, my lord.
Stop. Inaction on the part of the concerned police authority to register FIR prompts the petitioner to approach this court with this writ petition, seeking direction upon the concerned police authorities to take steps accordingly and to provide protection to the petitioner. Next paragraph, learned advocate representing the state respondents opposes this writ petition since there is availability of alternative remedy under section 175(3) BNSS 2023. Next paragraph. In terms of section 175 within bracket 3 BNSS 2023, petitioner is required to approach jurisdiction magistrate in the event complaint of the petitioner is not transformed into an FIR. Stop. In this regard, reliance is placed on the judgment of the Honorable Supreme Court reported in 2007, Volume 6, SCC 171, Aliu Padamsi and others versus Union of Indian House. Next paragraph. Hence, writ petition is not entertained and same stands dismissed. However, this order shall not preclude the petitioner to approach jurisdiction magistrate in pursuit of remedy. Next paragraph. Police authorities are also directed to maintain peace and tranquility at the local.
Yes, my lord. Grateful.
Next.
Item number 46.
I am the state respondent.
My lord, may I be I am
I'm the state respondent.
petitioner, my lord. In this matter, my lord, petitioner, my lord, purchased the land, my lord, from the father of the private respondents, my lord. My lord,
and name of the petitioners are recorded, my lord, page 16. We had a reported copy of it. Report. May I get a copy of the report?
Darshak, Shida report, madam. Police authority has registered a case.
Oh, yes.
Where is your complaint?
Not complaint, my lord.
Before the police authority?
My lord, at page, my lord, 18. Page 18, annexer P4, my lord. Prior to that, 17 also, my lord. 17, 18.
Yes, what is your contention, my lord? It is being alleged that peaceful possession of the petitioner is being disturbed by the private respondent.
But the record of right my learned senior friend has relied upon page 16. Kindly sees the entire, my lord, area of this plot, that is 10.93. What he has purchased is 0.06 of that. But it's an undivided property. He is trying to claim more than what he has purchased. And my lord, apart from that, there is no allegation in the letter of complaint, save and except that his peaceful possession is being disturbed. But I say, my lord, this calls for, my lord, even if they are aggrieved, my lord, this calls for a suit to be filed by them and obtain an injunction. This is absolutely a misconceived application, my lord.
Affidavit of service. Where is your affidavit of service?
My lord, I have served, my lord, but track report, my lord, he has
Matter
today-
is hard, Chedao. Matter is hard in presence of the learned advocates representing the petitioner, state respondents, and respondent numbers 5, 6, and 7. Next paragraph. It is alleged that respondent numbers 5, 6, and 7 are disturbing peaceful possession of the petitioner over the land in question, thereby prompting the petitioner to approach approach this court with the present writ petition seeking direction upon the concerned police authority to take steps which would ensure a right of the petitioner over the land in question. Next paragraph, next paragraph, land advocate representing the respondent numbers 5, 6, and 7 dispute submission made on behalf of the petitioner, and it is behalf of the petitioner, and it is contended that apart from the land purchased by the petitioner, an effort is made by the petitioner to enjoy possession of adjoining land owned by the private respondents.
It's all undivided property. Whatever he has purchased, whatever I am.
Adjoining land which is undivided property. Stop. Next paragraph, land advocate representing the state respondents has filed a communication dated 10 June 2026 of officer in charge, Hingolganj Police Station, and same is taken on record. Copies of the said communication dated 10 June 2026 are made over to the learned advocates representing the petitioner and state respondents. Represent petitioner and respondent numbers 5, 6, and 7. Next paragraph, having considered the having considered respective submissions made on behalf of the parties, it appears petitioner is primarily aggrieved by the acts and actions of the respondent numbers 5, 6 and 7 as peaceful possession over the land in question as peaceful possession of the petitioner over the land in question is being disturbed by those respondents. Stop. If petitioner finds that his right over the land in question is being denied by the respondent numbers 5, 6 and 7, in that event, petitioner needs to approach civil court in pursuit of remedy. Stop. Police authority is not the appropriate authority to decide interstate right of the parties over the land in question. Next paragraph. However, concerned police authorities are directed to maintain peace and tranquility at the local and to see that no untoward incident takes place. Next paragraph, writ petition stands disposed of, urgent of submission. Next.
Item number 47.
47, I'm for the petitioner, my lord. It's a post-poll violence, my lord. Petitioners are the oust from the has been ousted from their premises, my lord. They are not entered to the premises. My lord,
Now
we are
still entering into the premises.
my lord,
All similar matters are being disposed of. Grievance redressed.
my lord. So I can recite peacefully over the, my lord. Kindly protect me, my lord.
What protection?
My lord, no untoward incident happened at the recent.
Whether বসে অল্প ডেকে নেবো ছটফট করো না whether the petitioner ওরম করো না সব কর বসো
Petitioner is a supporter of particular political
whether
party.
the petitioner is staying at his own residence.
No, my lord. I am ousted from the residence.
Let there be a direction upon the police authority
Lordship,
to cause an inquiry, and if I find that
Lordship,
petitioner is staying there,
Lordship.
then he will face the music.
Lordship.
Lordship.
Lordship, only direct that.
Where is
so
your
my
complaint?
Well, page 25 is my complaint. The entire incident started from 5th May.
Where is your signature in the complaint?
Well, this is an email, my lord, page 25.
Email has to be signed under section 173. Have you put signature on your complaint as per 173 1 II?
My lord, this is only one.
Where you have stated in the writ petition.
My lord, only my lord to protection, my lord to.
I am asking you where is the complaint which was filed
when I
before
not
the police
entered to
authority?
the, my lord, to the
Please answer the query of the
Lordship.
This complaint is found an email letter. You have a right to file a complaint or to forward the complaint by email, but it has to be signed as per section 173 1 II. Where is the signature?
Signature is not there, my lord. This is email.
Where you have stated in the writ petition that
That has
your
not been
complaint
stated.
which was forwarded to the police authority was subsequently signed.
My lord, that has not been stated. My lord, subsequently police
Then
called,
you have
my
no
lord.
right. If there
Maybe,
is
my
no-
lord, there is a
If
signature.
there is no appropriate complaint, then there is no question of passing any order. 173
I am
1
not
2
able to-
says by electronic communication it shall be taken
Lordship.
on record by him on being signed within 3 days by the person giving it.
My lord, my lord, the police maybe, my lord, called, my lord, to sign, my lord. As such, my lord, there is no pleading, my lord, to respect to them. My lord, only, my lord, to
Mere
protect
sending a letter will not do. Then you have to attend the police station and sign it.
my lord, kindly direct, my lord. I will
direct nothing. It is your job. That is the groundwork which you have to make before approaching this court.
My lord, I am not able to enter the premises, and the, my lord, subsequently police was called me, my lord. Maybe, my lord, they take and
If
signature.
there is no valid complaint, what is the question of taking steps by the police authority?
My lord, since then, my lord, I am out from the premises, my lord. My daughter is the.
You show me that you have lodged a valid complaint signed by you, if it is via email.
My lord, this is the formal, my lord, complaint lodged through email.
Then
my
it
lord.
has to be signed.
Nothing there.
It may have been signed by the petitioner. In that regard, there has to be a statement or averment in the writ petition that you have signed it as per the requirement of section 173.
My lord, kindly adjourn, my lord. We made again complaint, my lord. I will come back, my lord.
No.
Kindly adjourn, my lord. I am not able to enter the premises, my lord. That is the, my lord, difficulty.
Yes, what is your instruction?
My lord, I already got the report from the police authority and the report is here.
What does it say?
It says that the matter is in civil nature and police has already took
paragraph?
steps. Sandesh Kali police.
Which paragraph?
Paragraph number, just I'm telling you. Paragraph number, my lord. Sure. দিও। Civil information, yes. FIR হয়েছে।
Already FIR has been registered, case started. Where you are saying? You are saying that civil dispute?
FIR
Why you have stated civil dispute? Why you have submitted?
It is there, my lord.
It's a responsibility representing on behalf of the state respondents.
Yes, ma'am.
If you cannot discharge it, don't take the responsibility.
Yes, ma'am.
Only for the sake of entering your name in the order, please don't appear before this.
Yes, ma'am. But it is there in the.
Please don't appear. And don't make wrong submissions. I am putting several questions to your learned friend representing the state petitioner, whether this was a formal complaint or not. Complaint was taken note of and the criminal prosecution has started. It was your duty to point it out before this court that already a FIR has been registered.
Yes, ma'am.
Now, when I put a question to you, then you are saying it's a civil dispute.
Issue.
Your wife made a complaint.
My lord, I made the complaint.
On 19th May 2026.
My lord, my wife made complaint. Subsequently,
So
my
that
lord,
is
I am not.
Why you have not annexed it?
My lord, that I am not. My lord, my wife is somewhere else. I am somewhere else, my lord.
Affidavit service you have filed. Affidavit service filed on behalf of the petitioner is taken on record. Next paragraph, learned advocate representing the petitioner submits that petitioner is victim of post-poll violence and could not stay at the and cannot stay at his own residence, apprehending physical assault. Stop. It is submitted that a complaint was lodged before the concerned police authorities and prayer is made for providing protection to the petitioner, which would enable him to stay at his own, which would enable the petitioner to stay at his own residence. Next paragraph, on behalf of the state respondents, a communication dated 22nd May 2026 of officer in charge Sandesh Kali police station is filed and same is taken on record. The copy of the said communication dated 22nd May 2026 is made over to the learned advocate representing the petitioner. Next paragraph. It is disclosed in the communication that based on the complaint dated 19th May 2026 of petitioner's wife, FIR was registered and a criminal prosecution commenced, being Sandesh Kali police station case number 263/2026 dated 19th May 2026. Stop. Next paragraph, in view of initiation of criminal prosecution, concerned police authorities are directed to take the same to its logical conclusion by completing investigation and submit report before the jurisdiction magistrate. Next paragraph, concerned police authorities are also directed to provide protection to the petitioner if occasion so arises, which would enable the petitioner to stay at his own residence. Stop. Writ petition stands disposed of, urgent xerox certificate copy. Next.
Grateful.
Item number 48.
48, I am here, my lord, I am the Panchayat Pradhan. Come before your lordship. I made a complaint. Lordship will find page 32.
Who is appearing for the respondents?
My lord, if it last of occasion, my lord, there is a direction, my lord, we have served all the respondents. I am the Panchayat Pradhan. I am not discharging. My lord, I am
How
not
you have
doing.
carved upon the state?
My lord, by hand, and my lord, rest of the
State
petition
by hand.
by hand, my lord, state by hand to
Upon
the
the, have
GP
you
office.
served upon the government pleader?
GP office, my lord.
When?
My lord, lordship, kindly make it not today. I find the GP. I may.
When you have served upon
22/5/2025, lordship.
Yes.
22/5/2025. Rest of the
Did you-
respondent was not served, my lord. We have served. This is the lord.
No, this matter was taken up subsequently on 22nd May 2026 when court directed to serve notice upon the respondents.
My lord, this is the subsequent affidavit, sir.
When you have effected service.
My lord, notice was served, my lord, 26/5/2026.
Upon whom?
All the respondents, my lord. But 1/6/2026, all the items have been delivered.
File your affidavits of service. Affidavits of service filed on behalf of the petitioner are taken on record. Stop. Mr. Chakraborty, Mr. Partha Chakraborty, learned advocate, in spite of service of notice, state respondents are not represented. Next paragraph. Mr. Partha Chakraborty, learned advocate, is present in court, who usually represents state respondents. Next paragraph. Mr. Chakraborty is directed to Mr. Partha Chakraborty, learned advocate, is requested to enter appearance on behalf of the state respondents. Stop. Learned government pleader is requested to regularize engagement of Mr. Chakraborty on behalf of state respondents. Next paragraph. A learned advocate for the state respondents is directed to obtain instructions by fortnight from date. And stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 23rd July 2026.
Great.
Item number 49.
Item number 49, my lord, I am reading for the petitioner.
I'm for this.
My lord, on the last occasion, my lord, we had prayed for an adjournment before your lordship. My lord,
Last occasion you prayed
we
for?
had prayed for an adjournment before your lordship. My lord, the reason being, my lord, two, my lord. One was, my lord, the service was not complete. My lord, your lordship had rejected the service. But second, my lord, I'm sorry, my lord. My lord, the second, my lord, there was an anticipatory bail application pending of the accused.
Second.
This anticipatory bail applications are pending of the accused before the learned coordinate bench, my lord, court number 28. But before the court number 28, my lord, there were submissions made from both sides that an undertaking was also given from our side that we will. My lord, an undertaking was also given from our side.
So what was the undertaking?
That we will pray for an
tendered?
adjournment. But we will pray for an adjournment before your lordship in the writ petition, my lord.
Oral or written?
But it was orally stated. It was recorded in the order.
Whether it was reflected in the order?
Yes, my lord, it is reflected. My lord, that's why I'm saying, my lord, I have to candidly submit before your lordship. My lord, in the meantime, my lord, this matter was adjourned by your lordship initially. The accused is not a party, my lord, in the writ petition. But they have filed an intervention application in the meantime. They want to be intervened as a party in the writ petition, my lord. And my lord, we have an objection to that intervention because your lordship knows, my lord, that as per the Honorable High Court's order, my lord, the accused has no right in an application praying for transfer of investigation. But we have also prayed that only, my lord, that the investigation which is being done by the police authorities are not being done, and my lord, there is no mandamus paid by us in the writ petition regarding arrest, my lord. Nothing of that sort.
If he is trying to my application, I can tell it is fit that I should be given the opportunity. First,
My lord, the intervention application is yet not been allowed, my lord. They have filed an intervention application.
So
wanting
what
to
is
be a
your
party.
stand? You are praying
My lord,
for time today,
yes,
or you
I wanted to brief your
oppose the
lordship.
application for
No, my lord,
impeachment?
I wanted to brief your lordship regarding a situation, my lord. And I'm saying that kindly adjourns the matter, my lord.
Well, I have filed the grand one, I have served them. It's for them to decide. The undertaking was of the previous dates. Hearing before your lordship.
That is the anticipated bail application of
My lord, this year, my lord.
Past, previously.
on the anticipated bail PRS bail application of whom?
My lord, the accused persons.
Accused.
My lord, it is the anticipatory bail has been filed prior, my lord, by them. We had entered appearance as a
So there was
de
an
facto
undertaking that not to press the writ petition,
not to adjourn,
not to
proceed
seek
in the writ.
adjournment before the court.
My lord, this honorable court. my lord.
However, on that date, they did not pray for adjournment according to us, according to them, they did. Despite being pointed out.
Yes, give me the number of PRS bail applications.
That's at page 17.
My lord, the my lord, 800 of 2026, my lord. My lord, and the order date is 22nd of May 2026. My lord, where there's a, it's recorded by the honorable court, my lord.
Addition of the
Oh,
Which wherein it says about
where this undertaking is recorded.
of my
This bail anticipated bail application was heard on several dates.
Yes, it has been heard. My lord, lastly, by that order of 22nd of May, my lord, there was an interim protection also
In
granted.
fact, we were enjoying the interim protection, oral being given by the state. During that period, they have come up before your lordship asking for different relief versus fixing.
No, my lord, that's absolutely wrong, my lord. In my writ petition, I have not done.
According to my assessment.
I have not done.
That is for sure. Which we will point out.
Issue. In reference to the order dated 22nd May 2026, passed by a coordinate bench on a pre-arrest bail application being CRM within bracket capital A close bracket 800 of 2026. It is submitted by the learned advocates representing the petitioner and applicant in implement application being Can 1 of 2026. Can 1 of 2026. That an undertaking was recorded by the coordinate bench in the order dated 12 March 2026, passed on aforesaid pre-arrest bail application, that applicant in the pre-arrest bail application would not
The petitioner is the petitioner is recorded.
would pray for an adjournment.
But the
Right. De facto complainant in PRS bail application would pray for an adjournment of hearing of the present writ petition. Next paragraph. In view of the order passed by the coordinate bench on 20.
This is page 84. On the same date, the matter was also before your lordship. However, they
This
did
was not brought to the,
And it was parallelly being heard, my lord. It was not at that point of time, my lord, on the same day.
On the hearing before, we came after completing the matter over there, and there was no prayer for adjournment before your lordship on that day.
I don't want to dispute the timeline and all that, but I had told your lordship what is the exact situation, and I have shown your the order also. my lord. Appearance was they will.
page 84.
Page 80
Of my
of our prayer. Can.
Yes, can. Page 84 of can.
He was the order passed in the
And in the writ petition, this order was passed on the same day.
same day, after the, I say after, because I had appeared before.
Now the court requires to indicate the time when the order is passed.
So far as your
Yes.
is concerned, it is there.
But my learned senior is stalwart at the party should not make all these submissions. But I have candidly told to your lordship what is the present situation. That can be that.
But you were also there. You could have.
We pointed out. He said no, that we didn't have the server copy at that point.
But that is not recorded in the order dated 22nd May 2022.
They did not pray for adjournment. The undertaking was given by them. They did not pray for adjournment.
But you were there at a time of tendering undertaking, so
I think your lordship also. But they did not.
My learned friend was there. But he had sought for an adjournment on the ground of correction of the cost title and a service also. But I'm telling you. Recorded in the order.
There on that day.
That's really sharp.
না না আগে সেন্টেন্সটা কি বললাম বলো তো
Let us be added as follows. তাহলে আর এই কনফিউশন হবে না পার্টি অ্যাড করে দিলে এই কনফিউশন
that de facto complainant being the petitioner herein করে দিন তার সঙ্গে stop. However, Mr. Ganguly learned senior advocate representing the applicant in Can 1 of 2026, representing the applicant in Can 1 of 2026, submits that in spite of tendering undertaking on 12th March 2026, in connection before the coordinate bench at the time of hearing of pre-arrest bail application, This was not brought to the notice of this court. No, not on 12th March, on 22nd May 2026. This was not brought to the notice of this court at the time of hearing of the present writ petition on the same day, that is 22nd May 2026, by the learned advocate representing the petitioner. Next, stop. However, next paragraph. However, on perusal of the order dated 22nd May 2026, passed by this court on the present writ petition, it appears that prayer was made for adjournment on different ground. Next paragraph. Be that as it may, taking note of the order passed by coordinate bench on 22nd May 2026, recording undertaking tendered on behalf of de facto complainant. Hearing of this writ petition is adjourned since court is apprised of pendency of pre-arrest bail application before the coordinate bench. Next, stop. Hearing of this hence hearing of this writ petition is adjourned. List the matter under the same heading for further consideration in the monthly combined list of August 2026. List the matter under the heading motion in the monthly combined list of 2026.
Direction by your lordship to serve upon the GP's office. Without a further.
I'm appealing from the state.
We need not need to serve afresh.
But on 12th March, it was required. Now, in the month of May, 22nd May, it was required to be pointed out.
I'm sorry.
I failed to understand that why it was not done.
We had attempted to serve, possibly.
Very well.
I'm sorry. Great.
Item number 50.
My lord, I am for this.
After my lord, directly please
My lord,
file a detailed report as the reasons are not clear in that report. Why the PSO has been withdrawn? Because
Yes.
the personal security officer, my lord, I have appointed
my lord, I am sir.
since 2013. I have made 11th May after the elections. On 12th May, they have withdrawn without not any communication, any written report. My PSO has been reported. But kindly see the last report, my lord. They have categorically indicated point number 3 that incident
Just a minute.
place on 2010.
Officer in charge does not and same is different. You have said convention of 26. Your box. Said convention of this person on personal security. Which paragraph?
But kindly, my lord, come to page 3.
Wherein it can be found that the reasons are disclosed for abrupt withdrawal of personal security officer.
My lord,
Which paragraph?
My lord, para number 7, my lord.
Paragraph
page
7.
Number 3, my lord. And also para number 81.
Perception. State perception. Deciding peacefully or resistance. So there is no threat perception.
Kindly see, my lord, the last.
Now, at the material point of time before this election result declared, you are holding a political post. So there was a threat perception, and there was since you are holding a political post, a personal security officer was provided to you. But after declaration of result on 4th of May 2026, you are not holding any political post. Now, so therefore, how long police authority will provide personal security officer to the political persons, those who are not holding the post?
They could have withdrawn before 4th May.
Yes.
What they have done.
What post you are you were holding?
Only a member. I was, my lord, assaulted.
Member of?
Yeah, All India. And my lord, I have.
But now you are not a member.
No. But my lord, one
So why you are not member now? Because you have left the party.
No, he is a member, but now he is not in a political.
Now he is not?
In a position to submit. That is why he is.
No, I am asking you that it is stated that at one point of time, if you come to paragraph 7, after declaration of the result, such threat perception is no longer subsisted. So perception no longer subsisted. At present, petitioner does not hold any political position, significance, does not hold any position of political significance warranting security coverage.
On my submissions, my lord.
Now, where is the change of your position pre and post election?
Kindly, I am requesting, my lord, kindly to read the earlier report once, my lord. The person sustained gun injury, my lord, and one for his.
When?
In 2010.
Yes, that's why in 2019, from 2019, PSO was provided. Now after election result, you are not holding any political post. So how long this PSO, lifelong this PSO will not be provided?
No, what I am saying, my lord, the trial is pending. It is on evidence stage. Till disposal of this criminal trial, my lord, I am requesting the continuation of the PSO.
Yes.
The criminal trials of those accused persons, they are on bail, and it is on evidence stage. I have annexed the case status.
Criminal trial of those accused.
Yes.
At the evidence stage. So whenever there is a criminal trial, then the de facto complainant or victim is to be provided with PSO. Show me any provision.
No, only submission is they could have told me they have intimated me.
Well, come back on the next date.
Only thing they should have written in.
You keep the affidavit with you, file it on the next date. It will retain its position. But dear, এটা কি জিনিস একটু দেখো তো, কারণ লাগলে দরকার অরিজিনাল ডকুমেন্ট দেখছি।